Yeah, the Senate Judiciary Committee will come to order. The clerk will call the roll, please. Vote aye if you're here.
Wait, what is this code you got to do?
It's 7-5 plus your district. What's it? 7-5 plus your district.
Yeah.
Well, they said that's not right.
Okay.
See, it did that on me yesterday.
Do we have a quorum?
Senator Lucas is here.
Is Senator Lucas here? She's here.
John,
Yeah.
hold up 1 second. The machine is broke.
iPad system's broken.
My iPad.
Yeah.
iPad's broken.
Mr. Chairman, you have a quorum.
Okay, thank you, John. Appreciate it. First of all, I want to welcome Senator Peake of Lynchburg. He used to be on the committee, and he's back on the committee. We appreciate the fact that he's now on the committee.
That'll be short-lived, Mr. Chairman.
We'll see. We'll see about that. Okay. The first person I promised would be Senator Sproul, Senate Bill 1113. He threatened me with death or bodily injury if I didn't put him up there. So the bill has to do with communicating threats. Is that right? Senator Sproul.
Thank you, Mr. Chairman. Mr. Chairman, we have a substitute on Senate Bill 1113. There's a substitute. I think in the hopper you have the original bill, but there's a substitute. So I have to move that the substitute.
Mr. Chairman, Charles here. I just uploaded the substitute to LIS, so it should be up there shortly.
We can't hear him, Mr. Chairman.
Yeah. Okay. Do we have it up? The substitute?
We can't hear him.
It should be coming up, Mr. Chairman.
Substitute.
The substitute should now be published, Mr. Chairman.
Okay, thank you. Why don't you, Senator Sproul, tell us about the bill, where it originated from?
Okay.
Yeah, well, yeah, let's, but he can, no, while we're waiting to see it.
Okay, thank you.
Tell us how that bill got started.
Thank you, Mr. Chairman. The bill of 1113 is put in at the request of the city of Chesapeake and the police department and the city manager. Now, I can read what the substitute says. I can't hear what he says. So, but you have on your screen the regular bill, but I have the substitute, and I can't hear what he says about the substitute. I can read the substitute, which it says on line 35.
Mr.
Yeah,
Mr.
Senator
Chair,
Deeds?
it's up, the substitute's on LIS. I'd move this, that we adopt the substitute so we can get it properly before us.
Okay, is there a motion been made, and Senator Sasslaw seconds to adopt the substitute? All in favor say aye. Aye. All opposed, no. Motion carries. Now, we need to see the substitute.
Okay.
I don't see it.
It's on LIS, Mr. Chair. If you go to LIS and click on the bill, and then click on the place where the line for amendments and substitutes, you'll get it.
I'm deficient. Maybe Legislative Service can explain. Charles or Kristen, can y'all explain what this bill's all about? What's the bill do?
All right. Yes, Mr. Chairman, Charles here. So what the bill does, it makes it a crime for any person who communicates a threat by any means to another person to kill or to do bodily injury to the other person, and make such threat with the intent to commit an act of terrorism, which is a defined term, or to compel the emergency evacuation of any place of assembly, any building, or any other structure. It is a Class 5 felony for if it's done by an adult, and a Class 1 misdemeanor if it's done by a juvenile. And the definition for an act of terrorism is basically a violent act that is done to either intimidate the civilian population at large or to interfere with the workings of either the federal government or a state government.
Okay.
Mr. Chairman,
Yeah, Senator.
I want to make sure that child make it clear. When you say adult, is any person 18 years of older. Is that right?
Yes.
Yes, an adult meaning any person who is 18 years or older.
And also, now, as far as under 18, it's a Class 1 misdemeanor. Is that right?
Mr. Chairman, that is correct.
Okay. Mr. Chairman, he has explained the bill to you, and we do have the chief of police and the city manager staff online if there are any questions.
Mr. Chair, could I ask staff a question?
Yeah, Senator Deeds.
Charles, there's another section that makes statements or threats in writing a felony, isn't there?
Mr. Chairman, to answer Senator Deeds' question, yes. This bill is drawn to that same section, and I believe what Senator Deeds is referring to is the provisions in A1 and in A2. So this bill does include oral threats, and what I would say is this bill includes what I would refer to as a third-party threat. So the intended, I'll say, victim of the threat doesn't necessarily need to hear the threat. The criminal conduct is basically making a threat and communicating it to somebody else. So, for example, if someone was to call up on the phone and to say, I plan on shooting up the state capitol, that is what it would be designed for. So it wouldn't necessarily require anyone who hears the threat to be the intended target of the threat, but is a third-party threat.
Yeah, Senator Sasslaw.
Well, let me ask you something, Charles. Suppose somebody, I say to somebody, I call somebody, or somebody calls me a name, a bad name, whatever. And I say to him, well, if you call me that again, I'll break your neck. I've committed a crime?
No, not under this bill, because here you wouldn't have the intent to commit the act of terrorism or to an emergency evacuation of any place of assembly or building.
So that's what it requires.
Right, that's what it requires. You'd have that specific intent.
Mr. Chairman,
Yeah, Senator Morrissey.
I would say to Senator Saslaw, in any matter like that, you always have to look to see if the defendant has the requisite mens rea or scienter. In other words, it was in their mind that they wanted to actually do what they said, as opposed to a wife telling her husband, I'm going to kill you, or vice versa. You have to have, in every criminal case, mens rea. And it would be lacking in the example that you gave and the two that I just gave.
Mr. Chairman,
Senator, who's this?
McDougall.
McDougall, Senator McDougall.
Mr. Chairman, going to particularly what Senator Morrissey said, I'm trying to think of examples, and maybe this, Charles, if you can help me out. So if somebody says, I'm going to
Mr. Chairman,
try to say beat you, and beat you and all your friends, and then you say, we got to get out of this apartment or room, you've evacuated the structure, does that meet the statutory requirement? If I say I'm going to come over your house and beat you and all your friends, and y'all leave the house.
It would be a crime if that were your intent.
Well, Mr. Chairman.
Yeah, Senator McDougall.
But your intent is going to be shown by the government only through what your words are in this particular statute. So
Correct.
And so
intent can be inferred. That's right.
So if I say I'm going to come over your house and beat up you and all your friends, then it would be a reasonable inference that y'all should evacuate or leave your house.
This is the language. This is changed. Change that? I think that's
Yeah, Steve?
Wouldn't you agree?
I'm wondering if we have anywhere a definition of emergency evacuation, whether that is a term of art that's in the bill. And I don't know if we mean it to be common parlance or if there is a specific definition for that.
Mr. Chairman, could I ask one more question
Yes,
with
Senator
this?
McDougall.
Maybe Senator Sproul or his chief of police can tell us.
I can't tell you nothing, no, ask me no question.
Okay.
Ask the chief of police.
Yeah.
If they could tell us what they're trying to accomplish with this bill.
Well, Mr. Chair, before that, I'd like to ask Charles a question. Does this emergency evacuation include somebody that stands in the back of a theater and yells, die, fire, fire, and everybody evacuates the theater? My understanding that was already punishable under the law.
Right, and Mr. Chairman, what I would say to somebody in the back of the theater yelling fire, they are not communicating a threat to anyone. They are just merely stating the word fire. There does have to be a threat made. So if the statement was to be, I plan on lighting this theater on fire, I want everyone to leave, or like, I'm going to, and actually it's not the place, it's the person. I plan on lighting the theater on fire so everyone will burn. That is what I think is the statute trying to get at. I think this, and you probably hear from the chief, I think the purpose of this is to act in concert with the bomb threat statute, so that, you know, if someone was to call up and say, hey, I planted a bomb in the movie theater, and everyone gets out of the movie theater, that would be a crime. But if someone was to say, I plan on coming to the movie theater and shooting a bunch of the movie theater, well, that falls outside of the bomb threat statute. And I think that's probably what the intent of the bill is trying to get at.
Let's hear from
Mr.
the
Chairman?
chief. Yeah, Senator
Mr.
Sproul.
Chairman, if we could hold, I think we have someone from the city manager staff or the chief of police on the line, I believe.
Yeah, members of the public, chief of police from Chesapeake, whoever's on the line. Hello? Is there anybody here to speak for the bill?
He's moving to the Zoom call now, Mr. Chair.
Okay.
Kelvin Ray, you can go ahead.
Yeah, go ahead. State your name.
He could be on mute, Mr. Chairman.
Yeah, whoever's there, if you could push the right button.
Kelvin Wright, we can't hear you. It might be a microphone issue on your end.
Here he is. Kevin Wright, is that it? Captain Kevin Wright?
Yes,
Okay, Chief of Police?
yes.
Okay, thank you. You're welcome. Could you speak to Senate Bill 1113 carried by Senator Sproul? Go ahead. We can't hear you. You got to push a button, I think. Go ahead, we're listening. Your mouth is moving, but we can't hear you.
Kelvin Wright, you are muted at the moment. You will have to unmute.
Yeah, unmute the button. Can somebody help him? We can't hear you. Shall we take a commercial break like they do on TV and get it fixed?
Mr. Chair,
Yeah.
while we're waiting, can I speak with both Charles and Mr.
Go ahead. Yeah. Senator
Benjamin?
Morsi. Senator Morsi.
To Charles and Mr. Benjamin, correct me if I'm inaccurate. The way I understand this bill is that if you communicate to another individual that you're going to threaten, they're going to bomb someplace, are not the most operative words of this legislation on line 21 that you make such communication with the intent to A, B, C, D. Is that correct?
Senator Morse, are you on the substitute?
Yeah. Yeah.
Yes. I'm on the, I'm sorry, no, I don't have the substitute, but the
that's
substitute
wrong.
has that same language.
No.
Excuse me.
It doesn't have that language? Yeah, we adopted the substitute. Okay. All right, who's speaking now?
I am, Mr. Chair.
Okay, Senator Morsi, go
The
ahead.
substitute has the language with the intent. Let me give you two examples. Okay. The second-year college student at UVA that has an organic chemistry exam communicates to the Virginia UVA police that there's a bomb in the chemistry building, and the building's evacuated. He's guilty of this charge. The individual who was walking with his friend at the state capitol and is disgruntled over certain statements that the legislature or activities of the legislature says, I should bomb this building or we should bomb this building. You then look to see, was it done with the intent to intimidate a civilian population, et cetera? And if the answer is no, then there is no crime there. So, and we look at intent through two things, statements and acts are usually overt acts. I think it's pretty straightforward, and I'm not quite sure what the dilemma is right in this bill.
This is Charles. If I can make a finer point to what Senator Morrissey is making. If you look at the bomb threat statute, which is 18.283, it provides that any person who makes and communicates to another by any means any threat to bomb, burn, destroy, or in any manner damage any assembly, building, or other structure, or any means of transportation. And then there's a Romanet 2, there's another one, an or who communicates by any means information, knowing the same to be false, essentially, of any bomb plot against the building, is guilty of a class 5 felony. The purpose, I think, of this bill is to get around maybe the requirements of having the magic words of I'm going to bomb my chemistry class by substituting I am going to shoot up all the students in my chemistry class, which I think may have been the issue that Chesapeake was trying to resolve here, was that the concerns were if they weren't talking about a specific structure, the bomb threat statute wouldn't apply. But if you were threatening the people inside the building, there didn't seem to be a statute on point, because in looking at the existing threats against person statute, there doesn't seem to be one that fits that situation where you're talking about calling up and saying, hey, I'm going to shoot up my chemistry class. That seemed to be kind of the conduct they were trying to get. And I see the chief might be available to talk right now. He seems to be other location, and I think I can hear him now. So I'll turn myself over to the chief.
Hi, can you hear me now? You got me now? Okay, basically what we were trying to accomplish with this bill, there seemed to be a gap in the current law that if someone called in and said, don't go to school tomorrow, I'm gonna shoot up the high school. That conduct fell through the cracks in that it didn't fall under section 18.2-83, threatening to bomb or damage any building. And also it didn't fall under 18.2-60, as there was not a threat communicated to a particular person. So that's why we introduced this legislation, hopefully to fill that gap and be able to cover that sort of conduct. I'm not picking up the audio on my phone for some reason.
Testing, can you hear us now? Testing.
I think he finished his remarks, Mr. Chairman.
Yes, I can hear you. I can hear you now.
What again is the problem that the current law doesn't cover? Explain that.
Well, yes, sir. The current law 18.2-83 covers threatening to bomb or damage any building. And current law 18.2-60, which we're looking to amend, covers threats to specific persons. So if I just called in and said, I'm going to shoot up a government building, it's not directed at Mr. Smith or Mr. Jones. I'm just going to shoot up this government building or government meeting. And I'm doing that with the intent to terrorize the occupants of the building or the participants of the meeting. This bill would cover that sort of conduct. Because we get calls from time to time or Facebook posts, don't go to school tomorrow, I'm going to shoot the place up. Right now, that falls through the cracks on how do we cover prohibiting that sort of conduct.
Mr. Chairman.
Yeah, Senator McDougall.
And Steve or Charles, why didn't y'all put this on already in the existing threatened to bomb statute?
Mr. Chairman, to answer Senator McDougall's questions, the original version was drawn to that, and I think there was some question as to whether or not this is a threat made against a person or a threat made against property, which the bomb threat is a threat against property, and this seemed to fall more towards the threat against a person. So that's why the substitute has this drafted to 18.260 as opposed to the bomb threat statute 18.283. Because this not being a threat made against property, this being a threat made against certain groups of people or certain people.
Where is the line? I'm only seeing page one. What line are you looking at that's being amended?
So the substitute is amends lines 35 to 39. It creates a new B2.
I'm not getting it.
So if you scroll down to the second page, you should pick it up.
Okay, all right. Oh, I see. All right. Yeah. And does everybody agree this is a gap in the law? Is there any dispute about that? Currently, this line 35 to 39 is not in the current law anywhere?
Mr. Chairman,
Yeah.
Surville,
Senator Serval.
thanks. So maybe Mr. Quagliato or Mr. Benjamin could, validate. I mean, it's not clear to me how if you communicate a threat to shoot up a school, that's not a threat to kill or do bodily injury to a person. I mean, I think it can be fairly implied from that language that the reason you're shooting up the school with a meeting is because there's people inside. And already in subsection A, it says if you do it with the intent to commit an act of terrorism, it's already a class 5 felony. So, I mean, was there a specific case where a judge found
Well, and
that,
I guess, Mr. Chairman, what the problem with A1 is, I think, is that it requires the threat to be communicated to a person regarding that person or any member of his family. So it needs to be communicated to a specific person regarding himself or his members, and that threat needs to also then place such person in reasonable apprehension of death or bodily injury to himself or its family members. So to Senator Serval's point, if the threat was communicated to, let's say to me, I plan on shooting up my son's school, then yes, that would be a violation of A1. But if it was someone said, hey, I plan on, shooting up, Richmond Elementary School, and I have no connection to Richmond Elementary School, and I pass it along saying, Steve Benjamin told me he planned on shooting up Richmond Elementary School. There is A1 violated because the threat hasn't been communicated to somebody who's a direct victim of the threat or puts anyone under reasonable apprehension of such threat.
Mr. Chairman?
Yes, Senator Serval.
Thank you. Well, first of all, I believe, now that I'm looking at it, I believe both A1 and 2 require a threat in writing as opposed to an oral threat.
That's also correct.
Mr. Chairman, and then I think that Section B gets into the oral threats, which only apply to school employees or healthcare providers. And so I guess this statute would pick up either an oral threat or a written threat to bodily injury to a person coupled with an act of terrorism or compel an emergency evacuation. I think that's partly what this is getting at, is it's casting a broader net for oral threats as opposed to written threats. Is that fair?
And Mr. Chairman, I would say that's definitely true.
Hey, Mr. Chairman.
Yeah, Senator Benjamin.
It's Steve. Because the chief's purpose includes a threat to do something in the future, say a threat that they are going to shoot up a government building tomorrow so that people don't go to that government building. If that's part of the intent, then a slight amendment is necessary. On line 37, subdivision little 2, you see that it includes compel the emergency evacuation. Evacuation is leaving a place that you are already at. To reach the chief's intent, after the word evacuation, you would want to insert the words or avoidance. So the intent would be to either compel the evacuation, the leaving of a building, or the avoidance of a building or a place.
Is there a motion to adopt that line amendment? Compel the emergency evacuation of or avoidance. Compel the emergency evacuation, comma, or avoidance, comma, of. On line 37, is that right?
I'll second Senator Morrissey's motion.
Okay. All in favor of that line amendment, say aye. Aye. All opposed, no. Motion carries.
Mr. Chairman,
Uh-huh.
so it strikes me, and maybe I've only been on this committee now for 2 years, and but it strikes me that part of the reason that there might be a dichotomy here between oral threats and written threats becoming felonies is because it's a lot easier to prove a written threat than is an oral threat. Whereas an oral threat, I could walk down to the police department tomorrow and say, hey, Senator Edwards told me he was going to shoot up the Pocahontas building tomorrow. And that could result in a felony charge being issued immediately, simply based on me saying somebody said something. Whereas part of the reason that maybe oral threats are excluded from the broader statute might be because they're subject to, A, they're harder to prove, but B, they're subject to being abused more. Number one. Number two, it also strikes me that I could see a lot of people in sort of a state of mental despondency, depression, bipolar, whatever, kicking off, whatever, saying all kinds of stuff that gets them stuck into this box. And while I understand that we've had a lot of situations where these types of threats have not been taken seriously by law enforcement, and there's people feel a need to react to that. I worry a little bit about, in some ways, how much we're criminalizing mental illness here. But I don't know whether there's a history. Anybody who here was around when the statute was written, whether they remember any debate or discussion about that. But I just think that might explain why we have differing standards in this statute.
Mr. Chairman,
Senator Morrissey.
let me ask the patron. Senator Sproul, the comment that Senator Serval just made would capture and make and authorize the issuance of a warrant if an individual went down to the police and said, so-and-so told me they're going to do this. It certainly would warrant a police investigation, but this legislation would authorize the issuance of a criminal charges based on that hearsay statement from Serval that Senator Lucas told me such and such. Is that what you wanted to capture?
No, sir. That's not what I understand it to be, no.
Okay. All right. I didn't think so.
Well, what is the, Senator Sproul, what did you?
Well, I was, thank you, Mr. Chairman. Mr. Chairman, based on what this bill is saying, this is not what the bill is saying. The third part, he was saying, I thought it was right direct to the point. It wasn't not involving the third person. So reading this, not being a lawyer, not reading this, I did not understand this to be that I go tell a policeman that someone said something. So that was not my intent. I thought my intent was to try to get it what the chief had said, not a third person.
Let's hear from the chief again.
Yeah, I was going to ask.
Mr. Chairman, I have a question for the chief.
Yeah, Kevin Wright, is that chief of police? Yeah.
Mr. Chairman, I have a question for him.
Senator
Serval
has a question.
Yeah, this is Mark Selesky, the Deputy Chief of Police. How could I help?
Okay, Mr. Selesky, so I appreciate the concern that you have that you might have people making threats to shoot up or harm people in buildings, et cetera, but we just passed the statute last session providing a red flag remedy where if people are threatening themselves or others in the situation, it seems to me you can get a red flag order and go to their house to at least seize weapons and start to ask questions. Or do you find that, A, have you used that remedy yet for these situations, or B, do you find that to be inadequate?
We haven't used that yet in any of the situations that we've encountered, but we thought this might help close the gap with, like I said, communicating threats. If someone came forward and said, hey, Mark told me he's going to shoot up the school tomorrow, certainly we wouldn't go right and get an arrest warrant. It would warrant some investigation, go interview Mark. Did you say this? And whoever's coming forward with this allegation, what other proof do you have? Are you willing to swear to this in a court of law or sign an affidavit saying that this is what he said to you? We certainly wouldn't just go on their word and immediately arrest someone for it.
Mr. Chairman?
Senator Morrissey.
The deputy chief just stated exactly what I would have suggested he do, that threat, hearsay threat, be investigated. This bill that Senator Sproul passes, and it's not his intent, would actually authorize the deputy chief to actually get a warrant for that person's arrest, when all we would want him to do that was necessary is to investigate it further. In some ways, I think, and I say this respectfully to my colleague from Chesapeake, this is a solution looking for a problem. The police can already go and investigate and say, did you really say this? Did you do this? We don't need a law enacted to do that. May I make a motion?
Yeah, Senator Morrissey.
With the patron's permission to pass it by for the day, to perhaps address some of these questions in a different, in a non-committee environment.
Sounds like a good idea. Is there
Yes.
been moved and seconded that the bill be passed by till Monday? All in favor of the motion, say aye.
Aye.
All opposed, no. Motion carries. Okay, thank you, Senator Sproul.
Thank you, Mr. Chairman.
Okay. Now, the next bill is, let's see, we have Senator Reeves. Senator Reeves, Senate Bill 1129. Who's outside there? Okay, Cosgrove. All right, Senator Cosgrove, of Senator Bill 1140. Cosgrove, gifts of real estate. Okay, Senate Bill 1140, Senator Cosgrove. Okay, pick up your push the so we can hear you.
Is that better?
Yeah, that's
good.
it.
All right,
Senator Cosgrove, Senate Bill 1140.
Thank you, Mr. Chairman. Basically, the reason I brought the bill forward is a friend of mine bought a piece of property, and luckily the title company called him and explained to him that a deed of gift was established in the city of Virginia Beach, and he did not then legally own that $3.5 million property. We had to go to the Virginia Beach Detective's office. We had to have an investigation done. We had to go through circuit court, and it took 3 or 4 months in order to clear this up. I'm going to ask that staff write an amendment for the bill that would only require that a person presenting a deed of gift at the circuit court's office to provide either a Virginia ID or a U.S. ID, so that that clerk would have that identity and an address. I've talked to the circuit clerks. It won't cost anything. It's very easy to do. All they got to do is take a photocopy of their license.
Mr. Chair, can I ask?
Senator who?
Deeds.
Deeds, Senator Deeds.
Virginia law already requires that the preparer's name and address be on a deed.
Yes.
So this is just being some additional information?
Mr. Chairman, Senator Deeds, what
Senator
happened in this
Cosgrove.
particular, what happened in this particular instance is that the person who brought forth the deed of gift had a falsified identity. The person that was receiving the deed of gift had a falsified identity, and even worse than that, the registrar accepted a piece of identification from the Nation of Islam to say, yes, this is acceptable. So all we would ask here is that the person bringing forth the deed of gift provide the clerk of the court with a current identification. Here's why. Because we went to court, the person who declared the deed of gift was fictitious, the recipient was fictitious, and the registrar made, a pretty bad mistake. So, this doesn't cost anything, but it would keep a lot of people from having the same thing happen. And by the way, Senator Deeds, it wasn't just my friend, it was 8 other properties besides him that were done at the same time, the same day.
Mr. Chair.
Yes, Senator Deeds.
So, Senator Cosgrove, this would require a certificate or something on the face of the deed showing what type of ID was, I mean, you wouldn't just show it to the clerk because that would be kind of meaningless, right?
Actually, yes, Mr. Chairman, I would ask that the clerk ask for that ID. All it would take is a photocopy of their driver's license or a passport.
Senator Deeds?
Okay. Well, no, I guess we just need some kind of fiscal impact from the clerks to see if they've got space to keep all these IDs or photocopies of the IDs and how much that would cost and how much it's going to cost us to pay them to do that.
All right, Mr. Chair.
Yeah, Senator Shervill.
Peterson.
Oh, I'm sorry, Peterson, sorry.
You are slightly different. My question would be, people file things in the courthouse all the time. They file lawsuits, they get marriage certificates, they file land records. We don't typically check IDs of people when they make court filings. I mean, oftentimes you'll require a notarization, so if they sign something, they have to show an ID. But, I mean, this is a very bizarre circumstance. And, I mean, you could just as soon have someone file a civil suit against me or Senator Stewart or anybody else and falsify their... I guess what I'm wondering is why land records has to be unique for showing ID as opposed to getting a marriage license, for example, or filing a lawsuit or I don't know, whatever else you might do at the courthouse.
Mr. Chairman, if I might.
Senator who?
Me.
Okay, who?
Me.
Oh, yeah, Senator Cosgrove. Sorry.
Thank you, Mr. Chairman. I'd answer Senator Peterson. I can't, for the life of me, think why somebody uses a fake ID to get a marriage license. I've been here for 42 years, okay? I mean, just saying. But here's the problem. If somebody does this deed of gift, and the clerk, by the way, has no option whatsoever than to record that deed of gift, that person can again take that documentation and start taking equity loans out of the house.
Oh.
And the owner, in many cases, has no idea what is actually happening to them.
Okay, Mr. Chair, if I can respond to that.
Peterson.
In land records, if there's a property in the jurisdiction, like say in the city of Chesapeake, and you come in with an ID, or you say, well, here's a deed of gift, well, you're going to have to show that the person that's the current owner is the donor. In other words, they're the ones deeding the gift to you if you're going to come in and now say it's your property. And, that's typically why we require notarized signatures, which, of course, if someone's going to lie on a notarized signature, that's a felony already. So I guess I'm still not quite understanding if in land records we already have everything cross-referenced, the clerk someone could come in and say, I got the deed to Chap Peterson's house, he just signed it over to me, and they're like, oh, hold on, well, you need Sharon's signature also. It just seems like there's got to be some existing safeguard to this.
Mr. Chairman,
Senator
I would
Cosgrove, go ahead.
Mr. Chairman.
Senator Cosgrove, go ahead.
Or Senator.
Yeah, Senator Cosgrove.
I would answer Senator Peterson. In this particular instance, in the city of Virginia Beach, this person was able to falsify not only their information, but also fictitiously forged a very well-respected real estate attorney on that deed of gift. When that comes through to the clerk, she or he has no option but to record that deed. In order to change that, the true owner of the property has to go through the circuit court of the locality, hire an attorney if they're not one themselves, and spend thousands of dollars just to get their property properly recorded by the clerk of the court. This bill is very simple, and asking for the amendment that I'm asking for, all it would take is for somebody to provide their driver's license or a passport or any other state ID, have a copy of that taken and put with
mortgage life insurance,
the recorded deed. That, I believe, would take a lot of the easiness out of falsifying these deeds, because it's going to be their name, their address, and their contact information.
Mr. Chair?
There's a lot of ways to commit fraud.
Mr. Chair?
Senator Peake, Senator Morrissey, then Senator Peake has a question.
Senator Cosgrove, let me ask you this, and I'm
Yes, sir.
really finding this discussion fascinating. I get what happened. The person went to a great deal of trouble to create a fictitious deed of gift.
Yes.
The person went to a great deal of trouble to forge a legitimate real estate attorney's signature.
Yes, sir.
What makes you think that if this step was in place, that they wouldn't go to the same lengths to create a fictitious license?
Mr. Chairman, I'd say to Senator Morrissey.
Senator Cosgrove.
Thank you, sir. The person who actually went to do this deed of gift gave a fictitious name, a fictitious address, okay? And when my friend had to go to court, we could not find either the person who put the deed in or the person who received the deed, because there was no legitimate information on either their name or their address.
Follow-up question.
Go ahead, Senator Morrissey.
And I want to hear from other people. I don't see the problem with that clerk saying, okay, by the way, let me see your license. Yeah. I get that. And I think they should do that. I'm just saying, Senator Cosgrove, that if they did all this other chicanery and mischief, it would be very simple to also get a fictitious license. So when the clerk said to him, I know you said your name is John Appleby, let me see your license, and they pull it out, either a passport or a license that says John Appleby, the correct address, and it's all fictitious. I don't see any downside to your bill asking for the license, but I'm similar to what Senator Peterson said. I'm surprised there's not some other safeguard, and this is outside my bailiwick, some other safeguard that's already in place.
Okay. Last year, I noticed the circuit court clerks opposed the bill. Senator Peake, do you have something?
But yeah, I think my question might be to Senator Deeds, who does more real estate. But is a deed of gift notarized?
Yeah.
Mr. Chair, I would say that I don't get to do much real estate anymore because I don't stay certified to do the commercial work. But every deed has to be certified, and most clerks I know that record documents has to be notarized.
Yeah.
And most clerks that we're in the jurisdictions where I practice law take a great deal of time to review the face of the document to make sure that all the T's are crossed, all the I's are dotted, with the notary seal, but also with the way that the instrument is executed.
Senator Norman, do you have a question?
I do, and I'm not a dirt lawyer, but someone who is going through the chicanery to do this, it seems to me what you really want to do is validate the legitimacy of the grantor's signature. You could have a grantee who is fictitious come in with a deed that is appropriately drawn on its face, but what you need to do is validate the grantor or the seller, not the grantee.
Mr. Chairman?
Mr. Chair, I would say that's exactly why a deed's notarized. The signature of the grantor is notarized. The notary has that specific job.
Mr. Chairman, I would say that somebody who is going to try to create a fictitious deed of gift, conveying it to a grantee, the grantor can go ahead and sign it, and if they are clever enough and bodacious enough to do that, getting a notary of a grantor isn't going to be a problem.
Mr. Chairman?
Okay, Senator Cosgrove.
Thank you. In speaking to Senator Deeds' concerns, this particular deed of gift was notarized, but improperly. Yeah. It was notarized by a legalized, licensed notary public who accepted a wrong form of identification. So, she was wrong, okay? I have worked with the clerks, and into Senator Norman's concerns, they don't want to have to go through all the hassle of getting all of the different deeds and all the signatures. I'm just trying to find an easy way so that people don't get really ripped off like 8 of these people happened in Virginia Beach. And it just seems to me that if we could require somebody bringing forth a deed of gift to provide a reasonable, valid identification, then that
Mr. Chairman.
basically would.
Mr. Chairman.
Yeah, who's
Mr.
that?
Chairman, over here.
Okay, Senator Stewart.
Thank you, Mr. Chairman. Senator Cosgrove, I think to Senator Norman's point, I understand what you're trying to do. Senator Norman explained that it's the grantor's signature that we actually need to verify.
I agree.
The grantor is not the one who records a deed. It is always the grantee that records a deed. So even if you were to give the grantee's ID, you still have not accomplished anything. There is no circumstance under which a grantor would go into the courthouse to record the deed, because it's the grantor that has conveyed the property out, and they have no more interest. It's always the grantee that records the deed. So I understand what you're trying to get at, but I don't see how that could help in this situation.
Okay, we need to move along. Does anybody have a motion? Last year, the circuit court clerk's offices opposed the bill. I don't know what they said today.
Mr. Chairman, if I
Go
just
ahead.
one last comment,
Go
please.
ahead.
All right, last year, the clerks opposed the bill because it required exactly that, the grantors to provide a certified copy of the deed. All this bill would do would be an inhibition for the grantee should they use a false identification. This is not very difficult for the clerks. I've talked to several clerks, clerk of Suffolk, clerk of Virginia Beach. They're okay with this. All they got to do is run the license, their driver's license, across the copier and put it on the deed.
For the grantee or the grantor?
The grantee, yes. So here's the deal. Basically, we had 8 people who were having their real estate stolen in excess of $12 million in Virginia Beach. And if it wasn't for one of those people just happening to just been closed, they would have never known about it.
Well, I've had a case similar to that too. It's a long story, but I'm not sure what you're doing here is going to accomplish anything. Anybody have a motion or?
I'll move, Mr. Chair, I'll move to pass the bill by.
Pass by
Yes.
definitely or to?
Pass it by indefinitely. And maybe we need to hire more staff for the Virginia Beach Clerk's Office, but I don't know that this is a problem anywhere else.
All right, is there a second to the motion to PB out of the bill? Is there a second? Senator Deeds have moved to PB out of the bill. Is there a second? I've been moved and seconded to PB out of the bill. All in favor, vote aye. All opposed, vote no.
I can't see the vote. Thank you, Brian.
He knows one. Okay, thank you.
Thank you, Mr. Chairman. I'll be talking about it on the floor.
Mr. Chairman,
Yes.
apparently, did I have Mr. Stanley's proxy? He would be an aye as well.
Okay.
So record.
All right, who's here next?
Can you all reflect that Stanley was an aye as well?
Okay.
I've got it.
Is Senator Reeves here? Who's here? Marsden, you have a bill?
1256.
1256. Senator Marsden. All right. Membership on the Criminal Justice Services Board. Okay, Senator Marsden, 1256.
Thank you, Mr. Chairman. This bill was came in the the current code language came in the special session that we held this year, and this small amendment, 2-line amendments that I had, were sort of approved by the folks who were putting the bill together to create this language, and they agreed that it was a good idea, but it was just a little bit past the time. They didn't want to go back and try to fix it. And what it does, it deals with the Department of Criminal Justice Services and their duties. And with regards to training, if I could direct you to page 5 and line 283. It merely adds that the DCJS, this group, will establish compulsory in-service training standards and I've added the language to include frequency of retraining. I spent a lot of time doing correctional training in my career, and there are some things that only need to be given once, and then you can just update people through memos. There are things like CPR where you need to be trained every year, and I did a lot of training in de-escalation and restraint, and this is something that needs to be done every couple of years. So I just wanted to put it in the ear of DCJS that they need to consider not just what the training is, but how often it is offered.
Mr. Chairman.
Senator Norman, Senator Norman, you have a question? Senator Norman.
Mr. Chairman, Serval.
Yes, Senator Sherville. Okay, Senator Sherville.
Thanks, Mr. Chairman. I just want to confirm that, yeah, Senator Marsden talked to me about this during the session, and I either forgot to stick it in, but it's anyway. I think it's a good idea. Senator Marsden's been involved in training large organizations for a long period of time and has very good judgment about this stuff, and I'd be surprised if there was any objection to it. So I'd move to report.
Is there any opposition? All right. Anybody from the public like to say anything?
Mr. Chairman, there is one other line amendment
on
page 6.
Mr. Chairman.
And it just further defines on line, 324, it talks about a social justice organization, and I've just added further definition that this social justice organization is engaged in advancing inclusion and human rights.
Mr. Chairman.
So those are the two changes.
Who's Senator
Mr.
Stewart? Senator Stewart.
Senator Marsden, what does that mean?
Well, I think I was trying to prevent here. I know what the authors of this bill were intending, and somebody could say that civil rights is something that was not intended as an organization that would be involved in looking at the responsibilities of DCJS. I wouldn't want an organization in there that claimed civil rights that were not towards inclusion and looking at advancing human rights as opposed to limiting them. So
you have an example?
Tweak in the definition.
Is there an example?
Where is that amendment?
What line?
Does the staff have that amendment?
What line?
Yeah, it's in the these are, I'm saying amendments, but they're just two line changes to the existing code.
What line? What line is
They're
it?
in the bill, the original bill. There is no substitute.
There's no amendment. He's just misstating. He's talking about the
so
changes.
is a motion made to report the bill?
Yes.
Is there any opposition?
I did, and voice goes seconds.
I've been moved and seconded that the bill be reported, Senator Martin, Senate Bill 1256. All in favor of the motion, vote aye. All opposed, no. Okay, 9-5.
Thanks, Mr. Chairman.
It snuck out of here. Okay. Okay, next bill is, who's next?
D-Step is here.
D-Step, is D-Step here? Okay. Senator D-Step. We're going to talk about vaccinations, or we're going to talk about the parole board, or what? Okay. Which bill is this?
Mr. Chair, members of the committee, thank you very much for having me today. First, if we could, let's talk about Senate Bill 1430. And Mr. Chairman, what happens today if a firearm has to get a NFA or a National Firearms Act background check? It takes about a year at the federal level. The FBI goes through an extensive background check on those weapons. And then afterwards, after the federal government goes through and looks at all of the different systems, they go through NCIC and NCIS, they go through the FBI systems, they go through all of them, then they get their approval from the federal side. And today, you have to, after you do that, you go through the state NCIC check again. Well, it's duplicative. So what we wanted to do was insert in here that if you've gone through the extensive federal background check, then you've already gone through basically the same one the state's going to put you through, only you're going to go through a more extensive version of it. So what we're asking to do is just say, hey, if you've gone through that extensive one, then it doesn't have to go through the state as well to do that transfer. And, Mr. Chairman, members of the committee, I'm happy to answer any further questions on Senate Bill 1430.
Mr. Chairman.
Well, you, Senator Strobel.
Thanks. I have a question for the state police, who I believe is on the line.
Yeah.
Can we confirm they're on the line?
Who's online? Somebody from the state police? Is somebody online?
Would the representative from the state police please raise their hand in the Zoom meeting?
Senate Bill 1430. Somebody from the state police on the line to answer a question? Yeah, I think the problem is, suppose you do the background check with the National Firearms Act, which is very extensive, I know. They rarely give it, say 5 years ago. Does that cover your buying a firearm today?
Mr. Chairman.
I'm sorry, Mr. Chairman, I can't hear what you just
Does
said.
it cover your buying a firearm today if in the past 5 years ago you you passed the National Firearms Act once upon a time? But would it, how
Mr. Chairman, I believe what you're asking is, if you had an NFA check 5 years ago, does that apply to a device that you're having it done again today? The answer is no. The answer is every single time you go through an NFA, it's for every new weapon that you're purchasing. So if you purchase a weapon today, you go through an NFA check, and it's very extensive. It takes between 1 year and 2 years. If you did it 5 years ago, you still have to go through another one today. If you purchase another weapon tomorrow, you still have to go through the same NFA check one more time.
well, if you want to buy a gun, why wouldn't you just go through a simple check?
Mr. Chairman, I'm sorry, I can't hear
Why
what
wouldn't you
you're
go through
saying.
a simple check with the state police?
Mr. Chairman. Serville.
Yeah, Senator Serville.
Sorry, I have a question of the patron. My understanding is that, first of all, I think this is a bill which is attempting to exempt these machine gun purchases from Senator Lucas's universal background check bill last session. Is that right?
I'm not familiar with his bill from last session.
Her bill.
Oh, I'm sorry, I'm not familiar with her bill from last session.
Mr. Chairman, further question.
Senator Serville.
Thank you. It was the universal background check bill, but which required a check on every transfer, and I think you're trying to exempt these machine gun purchases from that. But to put a finer point on it, my understanding is, you can correct me if I'm wrong, is that when the feds do a background check, the only thing they look at is NCIC, or NICS, the NCIC, NICS, NCIC, which is the National Criminal Information, NICS, which is the firearm database, and they do an Interstate Identification Index. Those are the only three the feds look at. But when the state police does a background check, that they also look at Virginia mental health records, Virginia protection order records, Virginia most wanted records, Virginia CCH file as well, whereas the feds don't look at any of those files to determine whether those people are barred. Isn't that right?
Mr. Chairman, I'm not sure.
Okay.
All of the different systems the state goes through, I know that the systems that they go through are the same, as I understand it, they're the same ones that the federal goes through when they do any NFA transfer, which they also go through FBI and all the other records.
Okay, is there anybody from the state police? Who else wants to speak?
Mr. Chairman?
Senator Serville.
Thanks. I checked with staff, and he said state police has signed up to talk, but does not seem to be in the Zoom room. But I was going to ask the state police to confirm what I just said, but apparently they're not in the Zoom room.
Mr. Chair.
Yeah, Senator who?
Peterson.
Senator Peterson.
If state police is here, I actually have a question. This is the bill we passed last year. And one of my questions is, has state police set up a system whereby you can have private sales registered? I mean, I've had this issue come up since July 1st, that you buy a weapon and you want to go through state police, because I know if you go to a gun store, they may or may not, run you through a background check, because it's obviously not their sale. But I'm just curious if state police has set up a system to actually process these background checks like we're requiring to have happen. And by the way, it was not transfer, it was sale.
Yeah, and also a gun sale at a gun show requires a background check too. You can't leave the building if it's a private sale without doing a background check right then and there. We passed that last year as well. Okay, anybody, why don't we do this, since somebody want to ask the state police, want to pass this by?
Mr. Chairman, I'm happy to take this by, talk to the state police, and ask even the questions that Senator Peterson has brought as well.
We'll pass it by for the day without objection. Bring it up on Monday, okay?
All right, Mr. Chairman, my next bill is the parental alienation bill.
Okay. It's Senate Bill 1308.
Mr. Chairman, I think it's 1368.
I'm sorry, I misread it. 1368, it's my glasses, lack thereof. 1368, Senator DeSteph, the abuse and neglect.
And Mr. Chairman, what this, if I may, Mr. Chairman, members of the committee, says any parent or guardian other than person responsibility or a person with responsibility for a child care under the age of 18 whose willful act or omission interferes with such child's contact and relationship with the other parent, guardian, or other person responsible for the care of the child, including unreasonable denying the other parent, guardian, or other person responsible for the care of such child or access to the child, is guilty of a Class 6 felony. And, Mr. Chairman, I believe when we brought this up last time that the financial impact on this was challenged and came back much, much lower than it was. But the issue is that you have one parent denying or making up information to ensure the other parent doesn't have contact or ruins the relationship with that child.
Well, isn't this something that happens a lot, and this is why we have juvenile courts? I've seen this kind of issue all the time. One parent's blaming the other child, keeping the child away. It's a juvenile court issue typically, or it could be a divorce court.
Mr. Chairman, this generally, I think you're asking, is this normally handled in juvenile court? I believe the answer is yes. But I'm having a hard time hearing you guys up here.
Mr. Chair,
Senator Deeds.
Part of the problem, I guess, is we're wearing masks most of the time. And when we speak, but I'm in juvenile court fairly often, and I see this is raising, in just about every domestic relations dispute, a felony charge. Every dispute that involves custody of children will result in a felony charge if this becomes law. I just don't think it's good policy.
Mr. Chairman.
Senator Searle.
Thanks. I second everything that Senator Deeds says. This is probably also unconstitutional, probably, is my guess as well. I mean, parental alienation is a real problem, but this is not the way to solve it. And, Mr. Chairman, I'd move the PBI of the bill.
Okay, any further discussion? All right, the motion been made and seconded to PBI Senate Bill 1368. All in favor of the motion, vote aye. All opposed, vote no.
Mr. Chairman, members of the committee, thank you very much.
Okay, thank you. Appreciate it. Okay. Next bill is who is not on the committee that's waiting to have a bill?
Mr. Chairman, do you have Senator Vogel in the queue?
Senator Vogel, are you in?
Do they have Senator Vogel?
Senator Vogel? I don't know if
She's not called in?
she's not on the bill, not in the committee? Okay, Hashmi, Senator Hashmi? Okay, Senator Hashmi, you got two bills? Well, let's see if Senator Hashmi is here. Is she here? Is she here? Here she comes, hot dog. Senator 1203 or 1340? Which one do you want to do first? Pass this by. Okay, Senate Bill 1340 be passed by for the day. And Senate Bill 1203, hate crimes. I hate these hate crimes. Go ahead.
Thank you, Mr. Chairman, and thank you for members of the committee. This bill, SB 1203, seeks to expand the definition of hate crimes in the Commonwealth. And you have in front of you in the bill the additional language that is now being included towards, I'm sorry, it's on line 18. person's actual or perceived race, color, ethnicity, religious conviction, national origin, gender, sex, disability, gender identity, gender expression, or sexual orientation. The other item that this bill seeks to include now in the hate crimes definition is the idea of a person's actual or perceived association with another person or group of a certain actual or perceived race, color, etc. So in essence, in addition to expanding the concept of hate crimes, we are also seeking to include the concept of perceived association with a targeted community. And this would help to address concerns that have happened in the past where individuals were targeted not because they were part of a protected community, but because they were associated with a protected community.
Do you have an amendment?
Mr. Chair.
Yeah, do you have an amendment, Senator Hashmi? Is there an amendment to the bill?
I don't believe there was an amendment to
All
the
right.
bill.
Okay, Senator Serval.
Peterson.
Oh, Peterson. You look so much alike. Go ahead. Senator Peterson.
Senator, I'm looking at this. I mean, it's a pretty massive expansion of this statute, and I guess my question would be, all crime that is committed reflects a certain animus towards the person that is the victim, and whether somebody's white or black or gay or straight or Democrat or Republican. I mean, it seems to me this would sweep up almost 95% of crimes. For example, there could have been vandalism in the city of Richmond this summer that was directed at some businesses because of the perceived association of that owner. They may have been perceived as being white. So I think before you change this statute in this massive way, to me, you're getting pretty far afield from the original purpose, but that's just my opinion.
Okay.
Mr. Chairman.
Yes, Senator Hashmi.
Mr. Chairman and Senator Peterson, thank you. And I know we are expanding that definition, but I think we already have the idea of what constitutes a hate crime in the Commonwealth, and the need is to include other protected communities, most especially communities that are impacted by gender identity, their gender expression, their sexual orientation. But the second element is there is the association of somebody targeted because of their association for a protected community. Just by way of example, we had a situation in the Commonwealth recently where an individual sought to harm and hurt a group of individuals because they were protesting racial injustice. Now, the victim of the attack happened to be a white individual, and therefore he was not protected under this legislation, the previous legislation, but he was targeted because he was actually associated with members of a protected community. And this bill would help to ensure that we are addressing those issues of hate crime. And Senator Peterson, I'm not a lawyer, certainly. You are far more astute than I am, but we do have legal attorneys and individuals who are ready to speak to this bill. We have also a representative of A.G. Herring's office, too, I believe, who is ready to address it.
Let me just ask this practical question. If we sort of pose this in terms of right-wing extremist groups, what if a left-wing extremist group beat somebody up? Would they be prosecuted under the statute?
Not if it's white people.
Mr. Chairman and Senator Peterson, yes, they would fall under this.
Okay. Is there anybody from the public that would like, first of all, any more questions of the patron?
No.
If not,
Yes, Mr. Chairman.
Yes, Senator Peake.
Peake, yeah. So based on what you just said, what happened this summer, the hypothetical you gave, if a group did attack somebody for being white, would that be a hate crime under this?
Mr. Chairman and Senator Peake, it is the definition is general. It does not specify any racial identity, but if the crime is targeting an individual because of his or her race or their identity, then they would fall under this definition.
Mr. Chair?
Yeah, Senator
Oh, I'm
Morrissey.
sorry.
Morrissey.
Okay.
Mr. Morrissey?
Yes, thank you. Senator Hashmi, under the existing law, it's a hate crime if somebody commits an act and it's motivated by, let's just pick one of them, sexual orientation. I won't wait till everybody finishes talking because I...
Yeah, that's all, sit down.
But if you write BLM on your business, somebody writes BLM on your business.
Y'all be quiet so that
Right now,
speakers can speak.
right now, under existing law, it would be a hate crime if somebody committed an act and was motivated because of the other person's sexual orientation. That's clear. This one now would allow for a cause of action if the act was directed towards a person who not only was associated with somebody that was gay, but it was a perceived association, which expands it even greater. Am I correct?
Mr. Chairman and Senator Morrissey, that is correct.
Okay, and I'm hoping that, one final question, Mr. Chair, and I want somebody to address this, maybe one of the legal folk that you mentioned, Senator.
Senator Morrissey, go ahead.
This would now cover an individual who commits an act against another individual who's not gay, but was walking near somebody who was gay, and the person perceived, because he was walking near the person that was gay, that he was also gay. Do you see how we're expanding it? And that's what I'm hoping that maybe not you, but one of the legal folk that you have queued up can address. Because that's really, as one of the folks on the other side said, expanding this broadly.
And Mr. Chairman and Senator Morrissey, the perception of association would be more than just simply walking nearby or in close proximity to the individual. It would be a perceived association with that individual of the protected class.
Okay, now let's go to the people. There are a number of people who are there to speak.
Mr. Chair, can I ask one more question?
Go ahead, Senator Deeds.
Because I think that this will maybe hone in on what the public will comment on. This goes beyond hate crime. You know, when you include 8.01-49.1 and 8.01-42.1, you create causes of action maybe for the first time in the Virginia law on the basis of some of these categorizations. Isn't that correct? You think?
These are civil actions.
So you create civil actions and you expand hate crimes.
Mr. Chairman and Senator, I believe the answer is yes, but we have attorneys on the line who will be able to answer that question.
I'm hoping they'll hone in on that.
Okay, we have some people waiting. The Honorable Shannon Taylor, Commonwealth's Attorney of Henrico.
God. Jesus.
Would you like to say something in favor of the bill?
Yes, sir. Thank you, Mr. Chairman. I want to thank Senator Hashmi for being the patron for this bill, because this did arise from a case that I did prosecute this past summer, where, as she indicated, we had an offender who was white, who was intentionally driving his vehicle through a Black Lives Matter protest. And because the individuals that he made contact with were also white, we were unable to efficiently and effectively make an argument to the court that just because the race of both parties was the same, that did not mean that we should not be focusing on the intent of the defendant, because our current law looks more at the victim and the victim's characteristics than it does looking at the offender and his intent. And so we worked with the Anti-Defamation League in coming up with this language to Senator Peterson's point that, yes, this is broadening the protected class, but that is exactly what's happening, is that we are identifying and currently identifying protected class members, and also believe that the perception to accompany the actual, again, falls in line with what we are seeing nationally as well. But again, this is focusing on the defendant's perception, not on the victim's characteristics. And I should also add, Mr. Chairman, that the Virginia Progressive Prosecutors for Justice also support this bill.
And this both creates a civil cause of action and a criminal case.
Yes, sir.
Okay.
So, Shannon, if I might ask a question.
Senator Peterson.
So if a white person beats up another white person, it can be considered a hate crime if they think that they're associated with black people. Is that kind of what we're talking about?
Yes, if
Okay,
the
just
white,
checking.
yes. In my, and I should also add too, that the facts are going to be very specific, and it's going to be up to the prosecutor to make sure that we are articulating the exact facts to demonstrate that association.
Okay, one further question, Mr. Chair.
Senator Peterson.
And I think you'll agree with me, regardless, you can still charge them with assault or vehicular assault or what have you. I mean, you're not in any way precluded from just charging them with simple statutory crimes.
Yeah. So, Mr. Chairman and Senator Peterson, yes, that is true. Although we do like to recognize that we like to charge the applicable crime. And when we are talking about someone identifying somebody and selecting them because of their protected class status, we'd like to have that option.
Mr. Chairman.
Senator Morrissey.
Ms. Taylor, isn't this a situation where the defendant heard that people were protesting down at a monument, got into his truck, and drove down there ostensibly because he wanted to either protect the monument or voice his own sentiment? Wasn't that the genesis of this prosecution?
And Mr. Chairman, to Senator Morrissey's question, there was actually, because we did already litigate this case in General District Court, and there was additional evidence where he acknowledged that he purposefully drove his truck to disrupt the Black Lives Matter protest.
Further question, Mr. Chairman.
Senator Morrissey.
Isn't this situation that the defendant drove his truck, was surrounded, another individual threw a balloon or a projectile at his truck, and he got out and he started fighting with a white person? Isn't that true, yes or no?
So, Mr. Chairman and Senator Morrissey, I regret that I can't just answer that with a yes or no question response because, because that's not the full set of facts. So I cannot answer that specific question in yes or no
question,
fashion.
Mr. Chairman.
Senator Morrissey, go ahead.
So this individual that got into a fight with a white person who threw a projectile at his car is being prosecuted for a hate crime because it involved other individuals that were associated with BLM. Is that right?
Shannon Taylor.
Yes, Mr. Chairman. Senator Morrissey, if I think I understand your question right, everybody there, white, black, whatever, were all there for the sole purpose of supporting Black Lives Matter. That was the essence of our argument, that regardless of your race, you were there to support Black Lives Matter, which is an entity and that is 100% about supporting the African American community. And we're missing the other point that this offender was a member of the Ku Klux Klan. And for those who do or do not know, the ideology regarding the Klan is about white purity. And that if you associate yourself with anybody who is not white, not part of the Klan, you are less than them. And so that was our argument to the court, to suggest that, anybody who was going to affiliate themselves with someone not involved in the Klan was not considered to be white per their race intentions. So we made the argument. The court did not agree because of the way the language of the code currently exists, which is why I came to Senator Hashmi with the help of the Anti-Defamation League to change Virginia's statute to be more in line with what hate crimes are supposed to be about, which is not about proving the characteristics necessarily of the victim, not about what the victim does, but focusing on the intent of the offender. And so this is what we're talking about, proving that the offender is seeing somebody else as a member of a protected class, and that we as the members of the Commonwealth do not tolerate that behavior.
Okay, now there are other people who would like to speak in favor,
Chairman.
I believe.
Mr. Chairman.
Yes, Senator
Stewart, just before, because I want to make sure I understand something here. With the hate crime statute in general, I can't remember, is there an enhanced category, or is it just that we get minimum mandatories for this? Because it was my understanding General Assembly is going to eliminate minimum mandatories this session. So as a practical matter, do we want to spend all this time debating it if we're going to eliminate minimum mandatories anyway?
Yeah, you go ahead, Ms. Taylor.
Yes, sir. Mr. Chairman and Senator Stewart, the way that, again, the Virginia Progressive Prosecutors for Justice are also supporting the General Assembly's move to do away with mandatory minimum, but it is our position, and I believe is supported, that the terminology that's being used is not mandatory minimum language. It's just dictating that if the court were to find an individual of the hate crime enhancement, that they would have to start with a 6-month period, although that could be suspended in part or whole. And then our additional language that we have added for the malicious wounding is providing, again, a sentencing range that is not a mandatory minimum term of imprisonment, which I think is the key language we're looking for in the abolition of mandatory times.
Okay, who else? Somebody's here to speak in favor of the bill as well. Lawrence West, is that right? Emmanuel Harris, am I right?
Yes,
Okay,
yes, sir.
go ahead, yeah.
Yes, Emmanuel Harris. I'm with the Black Coalition to Change. We support this bill. I find it somewhat puzzling and offensive that I've heard questions about the protecting the rights of white supremacists and the Ku Klux Klan. It's laughable. The history has shown that the black community is the one being intimidated, not the other way around. So I strongly support this bill. And yes, it needs to be expanded. And yes, the black community needs to speak up and stop taking tolerance and people who are lying with us to just say that we are relevant and matter. Thank God for you. That's all I have to say.
Okay, thank you very much. Lawrence West, you want to speak?
Yes.
Okay.
Yes.
Go ahead.
So I'm one of the people that actually occupy the monument down at Robert E. Lee Circle, and I will just let you know that to put some perspective on this, we are in defense of Black lives. So the people that come to antagonize us, they are literally in opposition of that defense. So I support this bill on that basis.
Okay, thank you. Brittany Whitley from the Attorney General's office.
Mr. Chairman, Brittany Whitley with the Attorney General's office. General Herring does support the legislation. It's consistent with his advocacy to expand hate crimes in the last 5 years. And to answer Senator Dee's question, hate crimes have been included in the civil action provision prior to this bill. So thank you.
Okay, thank you. Anybody in favor of it? Richard Johnson, would you like to speak?
Thank you, Chairman. I'm here on behalf of the Virginia Association of Criminal Defense Lawyers. We are opposed to the bill. The reasons that we are opposed to the bill are much like Senator Peterson. We feel that the bill is too broad and it touches upon too many individuals. And as regarding the malicious wounding aspect of it, someone who does a single punch to a sensitive spot on a face, drawing a little bit of blood, rather than facing 5 to 20 years under this bill, the exposure would be up to 60 years, which we think is too heavy of exposure for that simple act. So the Virginia Association of Criminal Defense Lawyers opposes on those reasons. Thank you.
There's no minimum mandatory, right?
They are not mandatory come July 1 in front of a jury, but the top end sentence goes from 20 years for that single act to a potential 60-year sentence as the bill is written right now.
Okay. All right. Who else would like to speak on the bill, one way or the other? What that is it?
Mr. Chair.
I can't read it. Lemnick, is that right?
Yes, Mr. Chair. Good afternoon. My name is V. Lamnick. I'm the Executive Director of Equality Virginia. We're the Commonwealth's leading organization advocating for equality for lesbian, gay, bisexual, and transgender Virginians, and we support the bill. Hate crimes are more than acts of violence. They are committed with the intention of inciting fear and dehumanizing entire groups of people. And unfortunately, as we know that individuals with intersecting identities, especially Black, Latinx, and Indigenous, LGBTQ people, are exposed to higher rates of violence. And so we think that this redefinition of the categories in this bill will help to further ensure that all diverse members of our communities are sufficiently protected by the law from hate crime violence, and that perpetrators of such violence are held appropriately responsible.
Okay, thank you. the American Anti-Defamation League. Meredith Weisel, is that right?
Yes, correct. Thank you, Mr. Chairman, members of the committee. I'll be brief, and we will submit some written comments to the entire committee. But as Shannon said, we worked closely with Senator Hashmi and thank her for introducing this bill, and we strongly support it. Just for background for everybody, the Anti-Defamation League has been around since 1913, and our mission is to stop the defamation of the Jewish people and to secure justice and fair treatment for all. I'm one of our senior associate regional directors for the Washington, D.C. regional office. And I just want to start by saying that all of us, including all of Virginia residents, have a stake in effective responses to violent bigotry, and hate crimes in particular demand priority attention. This bill is extremely important because it builds on the progress from last session last year that took great strides to strengthen and to improve the Commonwealth's hate crimes. And it ensures that all protected immutable characteristics are now covered under Virginia's hate crimes law. But another piece of it that is important to note is that Senate Bill 1203 would make 2 further amendments to the hate crimes laws that we see as absolutely essential. Just real quick, the phrase actual or perceived before the list of protected characteristics of the hate crime statute is something that we've seen across the country to make the hate crimes laws even stronger, to include that language to ensure that hate crime offenders who are mistaken about the victim's protected characteristic can also be held accountable under the law. And then the piece related to associational hate crimes is encompassed in Virginia's law. In other words, that the crime in which a victim is attacked not because of the victim's own protected characteristics, but because of their association with a person or group who has or is perceived to have those characteristics. So for these reasons, we support Senator Hashmi in introducing this bill, and we ask that the committee give it a favorable report.
Okay, thank you. Thank you. Does anybody else want to speak for or against the bill from the public? I'm not sure if there's more people or not. Landon, Love. If you need to speak, now's your time. Yeah, Love?
Yes.
Child
Hello.
Love, yes. Go ahead.
Yeah. I am here representing the Black Coalition of Change. And I just wanted to say that I definitely support this bill. I hear you all, some of you all saying that if this bill is passed, it will include or be too overreaching, and it'll include a certain percentage, like, I don't know, somebody said like 80% or 95% of crimes, something like that. But if that's the case, then that just shows that we have a problem as a society if this bill will affect that many crimes all at once. So again, I support the bill, and I thank you for your time.
Okay, thank you. Anybody else want to speak?
Mr. Chairman, when it's appropriate.
Is anybody from the public would like to say anything else? Any members of the committee like to ask any questions? Anybody?
Marcy has a motion.
Yes, Senator.
I have a comment first, Mr. Chairman.
Well, let me, Senator Peake's
certainly
in the queue. Senator Peake, you want to say anything? Yeah. I'm sorry. Okay. All right, Senator Morsi.
First of all, I want to thank Senator Hashmi because I know with certitude that her heart is in the right place. But let me tell you what we're doing right here. We're expanding the criminal code to capture people, and we're wrapping it under the umbrella of, in this particular case, BLM. I find that so offensive. And I think I have I've got skin in the game to say that because I have 4 African-American children. Now let's just talk about what we're just discussing about what we're going to accomplish with this bill. Because a white man goes down to an organization where they are legitimately protesting, and a white man throws a balloon at his car, and the white defendant gets out and gets in fisticuffs with him, it is a crime because it is at a meeting where BLM is engaged in a protest. That's like me going down to a gay pride parade, and I see another white male there, and I get into a fight with him for reasons entirely unrelated to gay pride. I am going to be prosecuted for a hate crime because I'm there I'm associated with a gay pride parade. And that's what's going on here. And I got to tell you, I am offended that folks brought this and then cloud it or wrap it up in BLM and suggest that if we vote against it, somehow we're not supporting the prosecution of hate crimes, because that's not what we're doing. This bill is offensive in so many different ways. I got a motion.
Well, before that,
Mr. Chair.
somebody else wants to speak. You'd like
Mr.
respond?
Mr. Chair, if I could just respond.
Go ahead, respond, yes.
Senator Morrissey, I understand your points, but this is not a bill that's wrapped up just for BLM. And I think you're speaking from a position of privilege if you see it in that context.
Oh,
because
my
this,
God.
May I finish, please?
Yeah, go ahead, finish. Go ahead.
This
Senator
bill
Ashman.
addresses not just race, but it addresses religious issues. There are members of the public, members who spoke, who are part of a oppressed community, attacked community, a terrorized community. Jewish individuals, Muslim individuals, Sikh individuals. These individuals are targeted because of perceptions of their faith. That is what this bill also seeks to address. This bill also seeks to address the issues of our LGBTQ communities, our transgender communities. There is constant homophobia, transphobia, all kinds of attacks made against individuals because of their perceived status. It is offensive to say that this is a bill that comes just out of the BLM movement. And yes, it does come out of the BLM movement. We spent months addressing the issues of race and racial injustice. But injustice affects many communities. And the crimes of hate are there in order to target and terrorize not just one individual, but to terrorize an entire community. And they do that effectively. They do it very effectively.
Mr. Chairman, I'm going to address that.
Just want, somebody else from the public wants to speak. Rashawn Richards, is that right? Rashawn in the public? Yeah, go ahead, Richardson. Rashawn Richardson, go ahead.
I appreciate the opportunity from all of you today, and hope we all are having a blessed day and are in good health. And actually, with the judiciary, I am going to side with, and I do understand what Senator Morrissey is speaking of. And from a psychologist's standpoint, being a person of color, I should say that I do see that from a perspective, that yes, this may be one-sided. But from that one perspective, you're also limiting yourself and being able to see that everyone else on the other side of that veil are the ones that are asking for the protection that you seek to say that you have yourself, to not be any type of assumptions or prejudice or type of discrimination because of your status or some type of affiliation that you have. So to even say that just being a white man, you can be subject to a racist or hate crime just because of the nature of the things that your culture or background has done. Okay. And in that sense, you will be under the protection too of that hate crime because of something you may not have done, but may just be perceived because of.
Thank you very much. We have limited time. Senator Norman, the last person to speak if you'd like, and then we'll need to have a motion.
Mr. Chairman, a couple of points. First of all, I thank Senator Morrissey for his observations on it. Number one, this bill is way too broad. Number two, it has a certain element of subjectivity in it. Number three, I've got to tell you, I take extraordinary exception in anyone, regardless of how much respect I have for them, suggesting that because I disagree with them, that I am speaking from a position of privilege. Just because I disagree with an advocating piece of legislation that people passionately embrace does not mean I'm speaking from a position of privilege. And I say, if I am privileged, it's only because I have something of a legal training and a lot of experience in litigating cases that gives me a little more insightful perspective on what's required on a burden of proof. But even if you are accused of a crime, you still have to go for it and prove your innocence. This is not a good piece of legislation.
Mr. Chair.
Is there a motion?
Mr. Chair.
Mr. Yes, Chair. Senator Peterson.
I just want to briefly say one thing. I'm going to make a motion. I appreciate this discussion. I appreciate the candor and the passion that Senator Hashmi has brought to this issue. I will say that if you think that religious hatred or hatred is limited to one group of people or one race of people, you're wrong. 20 years ago, my community was devastated when somebody put an airplane into the Pentagon, killed 300 people, including several of my constituents. And I made no generalizations or stereotypes as to other people of that religion. None. None. And so I do take a little bit of umbrage about assuming that people of one religion or one race or one gender are either uniquely suspect or somehow have a monopoly on maliciousness. We don't. We're all equally subordinate to God. And I just look at a piece of legislation like this, however well-intentioned, it takes a law that I think we put a lot of thought into, and it expands it in a pretty rapid fashion, and frankly, in my opinion, just my opinion, not without a lot of thought. So I'm going to move to PBI.
Mr. Chairman, I have a substitute motion or an amendment to a motion.
Substitute motion by Senator Serval.
I would just ask whether the patron would consider referring to the Crime Commission for
fine.
study. So that would be my amendment. It sounds like it's a friendly amendment. He accepts it.
That's fine.
Mr. Chairman,
Second, is there a second to the amendment to send it to the Crime Commission, to the motion? Substitute motion. Is there a second?
Second.
Okay.
Mr. Chair.
And seconded to send it to the Crime Commission. Substitute motion. Senator Dees.
The Crime Commission's fine, but I would point out, and one thing that's almost just basically been ignored by everybody that's spoken from the public and everybody that's spoken to the bill, is that this bill goes beyond crime. Right. It creates causes of action, and that to me is what makes it, so broad that it needs a longer look. I mean, I think I would probably be willing to consider expanding the crime, but the causes of action are something that needs some longer consideration.
Mr. Chairman.
Senator Norman, we got a limited time here, folks. Go ahead, Senator Norman.
I'm going to make another motion, but first of all, I would
Got
say,
a motion
and I don't
and a
mean this,
substitute motion.
I understand where we are procedurally, trust me. I say this with no malice of forethought, but I'm a little concerned about sending it to the Crime Commission. The Crime Commission is not what it once was. They have sanitized it in a manner that there's really not a diversity of opinion on it. And the executive committee is driving the studies and sometimes trying to influence the outcome of those studies. So I think that, with all due respect to Senator Serval, that we ought to deal with it here. So I'm moving the previous question.
The previous question, meaning the PBI, that's non-debatable, I believe. Non-debatable. Am I correct? All right. The previous question has been moved, meaning we'll order the previous question. Should we vote? If you vote for the previous question, that means the PBI bill, first bill motion, will be the one we'll take up. All in favor of the previous question, ordering the previous question, vote aye. All opposed, vote no.
Ayes 9, no 6.
So the previous question is ordered, is that right? Okay, the previous question is ordered. So the previous question is, shall the bill be passed by indefinitely? If you vote aye, if you agree, vote aye. If not, vote no.
Ayes 10, noes 5.
Ayes 10, noes 5. The bill has been passed by indefinitely. Sorry, Senator Hashmi, I happen to like your bill myself.
Thank you, Mr. Chair. Thank you to the members of the committee.
Work on it, bring it back maybe, okay? All right, thanks so much. The next bill is Senator Reeves. Does he have, we finished? We got another one, Senator? Yeah, Senator Reeves. Would you like to present your bills? Senate Bill 1129, Veteran Service Organizations, paramilitary activities. Senator Reeves.
Thank you, Mr. Chairman. We had taken this up, and I was on the call via Zoom, and I think there were a couple questions with regard to how do we ensure some protections when our veteran service organizations are conducting honor guard ceremonies. So I have an amendment. If Charles is on, if he could explain the amendment and the need for it.
Yes, Mr. Chair, I'm on it, and a substitute that I've published. It should be up shortly, but basically, the substitute just adds to the original bill at the end of the new section, unless such member violates this section with malicious intent. So that the amendment basically provides the exemption for the members of the veteran service organizations to the statutes they are drawn to, unless they violate the section with malicious intent, in which case the exemption would not apply.
So, Mr. Chairman, I think that would suffice to handle. I think it was Senator McClellan's question on the Zoom call, if I remember. It was a few days ago, and I'm growing tired, but I think that wraps it up. So that would make that carve out for those folks to perform honor guard ceremonies.
The question I have, we talked about it earlier, Senator, that the guns are not loaded. Is that right?
Mr. Chairman, again, we had talked about that on the original call. The only time that those typically they're incapable 99% of the time, unless it's a unit that's designed to do a 21 gun salute, in which those cases are usually also plugged but fire a blank, and they're still plugged weapons.
Let me ask you, does anybody know whether or not this is already legal? I mean, that they can do this anyway? It's using a congressionally chartered, officially recognized Veterans Affairs organization. Can they do this already?
Mr. Chairman, I think Charles could probably help us with that as well.
Charles, what's the answer to that?
Mr. Chairman, I guess there is some question as to whether or not this is necessary, because what the exemption provides, or I should say assumes, is that the members in these veteran service organizations are acting in violation of the law, because otherwise the exception wouldn't be necessary. And from what I understand, and what Senator Reeves has communicated to this committee, is that at least counsel to the veteran service organizations feels that there is some sort of criminal exposure there, and that's why they put the amendment, or put the bill in there. Okay. So that's the intent of the bill, and what I would say is,
clears up a question.
Yeah.
Okay. All right. Any more questions about it, Senator
Bill? Mr. Chairman.
Yeah, Senator.
It's Steve.
Senator Steve. Steve Benjamin.
I have nothing but respect for the veteran service organizations and would want to do anything necessary to protect them and their activities. But this bill would only be necessary if they were brandishing their firearms in such a manner as to reasonably induce fear in the mind of another. And I can't imagine that they are doing that. And if they are, of course, they should stop. But I just don't think they're doing that. And I can't imagine that there's been any threat of prosecution or charging them for whatever it is that they do. A second point, Mr. Chairman, is that if, in fact, this is necessary to protect those groups, the question would be, why isn't it then necessary to protect any armed member of law enforcement? And the answer is because none of these associations or groups or individuals are brandishing their firearms in such a manner as to reasonably induce fear. Hence, the bill just isn't necessary.
Mr. Chair.
Let me ask you this. Can you amend this rather than making it the negative, the revision shall not apply? Say a member of a congressionally chartered, et cetera, is not considered to be brandishing a firearm.
No, because what if they do brandish a firearm? I mean, what if them goes rogue and starts pointing at people along a parade route? Then you certainly do want to prosecute them. The only way to amend this would be to say it doesn't apply to these groups unless they violate the law. And that's circular. It's simply not necessary.
All right.
Mr. Chair?
Yeah, who's this? Senator Morsi?
Yes. First of all, I think Mr. Benjamin was reading over my shoulder some of my notes. I would point out that on line 39, it says, in furtherance of a civil disorder. On line 43, it says, in furtherance of a civil disorder. And in line 46, with the intent to intimidate any person or group of persons. And I can't see, Senator Reeves, any color guard, honor guard, Boy Scout troop, whatever, that would come within those. But what I think Senator Reeves is trying to do is maybe put a super safety valve on that to cover any possibility. And towards that end, I would ask this, Senator Reeves, why limit it to a congressionally chartered or recognized by the U.S. Department of Veteran Affairs? What if we had a Virginia honor guard from the Virginia National Guard, or as Mr. Benjamin said, a Henrico County color guard? Why aren't we giving that extra layer of protection that you're desirous of doing to those groups instead of limiting it to a congressionally chartered organization?
Mr. Chairman,
Yes.
Senator Morsi.
Senator Reeves.
I was trying to narrowly define it and keep it close because I wanted to have an opportunity for it to pass. But you're certainly right in your comments that there are other groups that out there that provide honor guard ceremonies for different various groups, burial, honor guards, and all those sort of things. I think the National Guard is covered under the, as a military force, they do drops all the time to supplement our active duty force. And then law enforcement, they're already carrying firearms, so they don't fall under there. But there are some that do these things, such as the Young Marines and some of those.
Well, what about VMI marching somewhere, the students of VMI with guns in a ceremony? I mean, that's the trouble. You start, I think Steve Benjamin's got a good point that you start carving out who's not. I mean, I don't know where you stop there. And I'm not sure I agree that it's that ambiguous. I mean, anytime you like the presidential, decided today, we had, of course, they weren't armed, but had the president's own, which is the United States Marine Corps band playing. Now, they weren't carrying arms, but I can see it's not infrequent in any kind of parade. You have people who are veterans or who go to VMI or Virginia Tech or somewhere else, United States Military Academy or Naval Academy marching with guns. It happens pretty frequently, I think. So I'm not sure if we put this in, it's adds some confusion. That's the problem I'm having with it.
Mr. Chair, can I ask the patron a question?
Senator Morsi.
Senator Reeves, would you be, and it's just a suggestion, we're talking this through, the provisions of this section shall not apply to any, what about simply putting lawfully recognized color guard or honor guard? I may want to put another group in there, but does that accomplish the extra layer of protection that I think you were trying to accomplish?
Mr. Chairman, I think that would. I'm trying to think of all the various groups that I've seen over the years that actually perform that.
Why don't we do this?
Wear uniforms. So
we'd like to take this battle Monday so we can get some other things done. And see if you want
Mr. Chairman, I'm at the pleasure of the chairman and the body. I brought this bill at the request of our veteran service organizations that are definitely afraid that with the political tensions that are going on nowadays, that when they go to try to do something, I think best case, I think they're worried.
I think we can work on it a little bit better. And without objection, we'll put it off to Monday and maybe come up with a better amendment that accomplishes what you want and still makes it more generic.
I'm fine with that, Mr. Chairman.
Okay. All right. Without objection. Senate Bill 1129 will be put off to Monday. Then next bill, Senator Reeves, 1332. You're kind of flip-flopping what we did the other day. Yes, last year, I think. Go ahead.
Mr. Chairman, 1332 was brought to me by Senator Favola via the state police. Mr. Huggins should be on the call. But what this bill does eliminates the requirement that law enforcement officers shall not use deadly force against a person unless he has provided a warning to the subject of the deadly force that will use deadly force if feasible and exhausted all other options or such options do not reasonably lend themselves to the circumstances. What this bill does is it shifts these requirements to the factors considered in determining whether a law enforcement officer's use of deadly force was proper. I have a whole page of background if you'd like me to go through it, but if you'd like to listen to Mr. Huggins and why the state police originally brought the bill, I'd let him explain.
Mr. Huggins, it looks like we have these in there under 2, 3, and 4 of the bill passed last year, but it's put in a different section. Why is that better?
I'm not sure about why it's located. I'm here to talk about the substance of why we feel this change is necessary.
Okay, go ahead.
Mr. Chairman, members of the committee, thank you very much. I need not tell you all how much how policing has changed in Virginia in just a few months. Right now, Virginia's law enforcement community in general and the state police in particular, there's a lot of apprehension, a lot of worry about their job in terms of, am I doing my job correctly? What are the possible repercussions if I make an honest mistake? It was recently as this past fall, I think some of you, in fact, I know some of you visited the State Police Academy and you went through an informational session that included an opportunity to exercise the Milo system, the shoot, don't shoot. And what I think that demonstrates is how quickly these life and death situations unfold. Yeah. And for any trooper, an experienced trooper or a young trooper, to have to sit there in the heat of the moment and go through this mental checklist of am I performing my jobs correctly? They are putting themselves and potentially others in harm's way. And so for that reason, we think reasonableness should be the standard here. It's concerning that judges and juries and defense attorneys can review our actions literally frame by frame by frame in the comfort of their offices or a courtroom, as opposed to that trooper, particularly a young trooper, on the shoulder of a road at 2 o'clock in the morning, having to exercise this mental checklist. So what we're asking for is for reasonableness to rule the day here, and understand the gravity of these situations that these troopers are confronted with, and police officers and deputy sheriffs all the time. And we ask for your favorable consideration of this bill. Okay. Thank you very much.
Anybody else in favor of the bill? And what's wrong with doing it this way, the way this bill does it, rather than the way we did it last year? Any objection to the bill?
Mr. Chairman.
Yeah, Senator Sherville.
I'm sorry, Mr. Chairman, this is a bill we just passed, which isn't even gone into effect yet.
Right.
It doesn't go into effect until March the 1st. And we spent a lot of time working on this language to try and, number one, we were trying to achieve some objectives. One objective was we were trying to require, I believe there was something called "Can't Wait for Aid," or I forget. There was eight things that we were trying to implement in the policy, and warnings before the use of deadly force was one of them. We recognize that warnings are not always possible before deadly force is used, which is why we put in "if feasible" after we took feedback from the law enforcement community. The reasonableness standard is right in there under the totality of the circumstances, which is consistent with the existing U.S. Supreme Court precedent. And we also wanted to make clear a statement of policy that deadly force was only going to be used if all other options had been exhausted, given the circumstances. And that's what is all being struck out, and I guess part of it's being moved back into a different part. But subsection 2 here was all based on, I forget the name of the case, but I'm sure Mr. Benjamin or Mr. Quagliato can remind me of it. But we spent a lot of time working on this language and coming up and with taking a lot of vetting with a lot of stakeholders, and to just go and start editing it again before it's even gone into effect, to me seems premature. And so, that's,
At the same time, I think it's got a good point that it's puts the emphasis on the reasonableness, and then it has a totality of circumstances listing. It basically takes paragraphs 2, 3, and 4 and puts them at the bottom. So they're still there. It's in a different category. And what's wrong with doing that? I see the point. Anybody from Legislative Services?
Mr. Chairman, that's not what it does.
Yes, it does. Well, for example, number 2, if feasible, according to the existing law, the law enforcement officer has provided a warning that the subject of the deadly force he will use deadly force. And that goes down into the category of under 2, Roman numeral 6, whether the law enforcement officer provided a warning to the subject of the deadly force prior to using deadly force, if feasible. It says the same thing.
All right, Mr. Chair?
Yeah.
With apologies to Senator Reeves, but I'm going to agree with Senator Surville. We spent a lot of time on this bill last summer. It was Senator Locke's bill, and we're basically rewriting it after we passed it before it even goes into effect. And
who would like to speak for or against the bill? You got Wayne Hogan spoke for it. Who else wants to speak for it from the public? All right. Anybody from Legislature? Steve Benjamin, what do you think? Charles?
At this point, I don't have any thoughts, Mr. Chairman.
Okay. All right.
Other than what's been expressed.
All right. Who's against the bill? And why would you be against it? It seems to me it says the same thing. It's just worded differently. Who wants to speak against the bill? Okay, Andrew. Andrew Goddard. Okay, go ahead.
I do. Emmanuel Harris.
Who? Emmanuel Harris?
Yes.
Lawrence Webb.
Emmanuel Harris, go ahead. You're against the bill?
Yes, sir. I'm against the bill. As they already said, they've gone through a lot of work to put protections in place. And why are these protections in place? Because innocent civilians who are 9 times more likely to be killed as African Americans, that's what started all of this. So we are not okay with any layered objective to make it easier to kill African American civilians. Let me say, I have officers in my church. I have wardens in my church. It's not about being anti-police. It's about accountability. And the police need to be held accountable like everyone else. I understand. My father was law enforcement. I understand fully. But the problem is I've been stopped probably more than 30 or 40 times in the Richmond metro area, and I have no criminal history.
Okay.
So this bill was put out there to put protections in place. I think it was done correctly. This, I strongly oppose undoing it, the previous bill. Right. So I strongly oppose 1332.
Lawrence West, I believe, very briefly.
Yes.
30 seconds.
Yes. All right. So the first thing I want to say is that people consistently militarize the police against Black people. So if you're looking at this bill from a perspective of a Black person, you know that the police can actually be militarized against you, called on you, and then if they're not executing the proper strategy, they will potentially kill you utilizing the death penalty on the ground. Right. Now, the second thing I want to say as regarding to this bill is that I definitely have as Senator Morrissey would say, skin in the game, because like I said, we're actually out there. And yesterday, during, I'm sorry, not yesterday, but on the 18th of MLK Day, there was literally a situation where we were, we had someone get arrested, and when they were being arrested, we as a collective talked to these people and talked to this person, and we actually de-escalated the situation on the ground without any type of police training. So it can be done, whether they're a new person, old person, it can be done, and we have done it.
Okay, yeah, thank you. It seems to me the bill says exactly what was said before.
Mr. Chairman.
Just rewords it a little bit. Lawrence West, do you have something to say?
Mr. Chairman.
Briefly, Lawrence West.
Mr. Chairman, I'm in the queue to speak.
All right, Andrew Goddard, I want to the public here. What do you have to say?
Yes, Mr. Chairman. First of all, I do recognize that police work is very, very difficult and that sometimes it's necessary to use deadly force. However, I believe moving the 3 pieces down into section 2 is moving them from before the person is shot to the after event examination. And at that point, somebody's dead.
All right, okay.
And you're moving it to whether the police officer is going to lose their job, but the person is already lost their life. So we oppose this bill.
All right, Child Love, you against the bill? Child Love?
Yes, I am definitely against this bill.
Okay, go ahead.
I'll be brief. Basically, I just wanted to say that from what I understand of reading this bill, it takes out the requirement for an officer to warn you that he is about to use deadly force. Now, I read the bill several times. If I'm misunderstanding that, then please let me know. But that was my takeaway from the bill. And to me, it is an insult that they are trying to, Bryce Reeves wants to pass this bill when the other bill hasn't even been put into effect yet. Okay. It's a slap in the face. It's a slap in the face to people who are victims of police brutality or police gang violence.
Okay.
So I definitely oppose this bill, and thank you for the opportunity to speak today.
Okay, Senator Peterson, and who else?
Mr. Chairman, Servo.
Servo, go ahead, Senator Servo.
This is my memory, Mr. Chairman, as to why this was constructed this way and why this proposed bill is destructive to what our intent was. The first thing you have to remember is that what we attempted to do was to codify a series of standards to guide police use of force and also the use of deadly force. And the reason we codified that was because we wanted to have some rules that could be used as the basis of a decertification proceeding, because formerly decertification was only allowable for a positive drug test or I think one other thing I can't remember right now. And so we put these bright lines in the top so that it was clear that if you don't give a warning before you shoot someone and it's feasible, or if you you do not exhaust all options before shooting somebody when it's feasible, an officer can be decertified. But by the purpose of paragraph 2, this has to do with deadly force and the Supreme Court test. And I'm pretty sure if you go read the U.S. Supreme Court opinion, it doesn't say anything in there about warnings or exhausting options. And so we're starting to mix up apples and oranges and undermine the ability of what will eventually be the Department of Criminal Justice Services to decertify somebody for any of the reasons that are set forth in 1, 2, 3, or 4 by moving it all down to subsection B2. And so that Mr. Chairman, is, I think, the risk that arises by making these things, instead of making these 4 things bright lines and putting this into some totality of the circumstances reasonableness mushy place, it reduces our ability to create accountability when the policies that we articulated in 1 through 4 are violated.
Mr. Chair.
Who's speaking?
Morrissey.
Morrissey.
Thank you, Mr. Chair.
Yeah, just keep it short, please.
I will. Here's the reason I like the existing law. On line 15, it makes a bright line, that word has been used, prohibition against using deadly force unless certain things are done. All of those are now struck, and it's now on line 23, it talks about deadly force being proper, and it's more of a negligence component. I like the way it existed before because it prohibited deadly force unless certain things were done. And Senator Reeves, while I think I understand why you were doing it, that's why I'm going to vote against this bill, because I liked the bright line components as to when law enforcement could use deadly force.
Okay, anybody else in the committee want to say anything?
Mr. Chairman.
Yeah, Senator Norman.
I have no misgivings about the direction this bill is going, and it's heading south. It is perplexing to me that there would be objection to introducing an element of reasonableness into this. All of the judgments that are going to be considered are going to be in the rearview mirror after the action has actually been taken place by the police officer. And I appreciate that there are what have been referred to as bright line standards that are going to be considered. A concern that I have is when DCJS is going through a decertification hearing, that they are going to strictly read the code as it exists. And if in fact there are only bright line standards in it, and they know that the General Assembly has considered and rejected the introduction of an element of reasonableness in it, that they are going to feel precluded from exercising reasonable insight to it. And I think that's very dangerous, and I'm a little perplexed by it.
Mr. Chairman.
Yeah, who's this?
Mr. Chairman.
Yes.
Stewart.
Okay, Senator Stewart.
Thank you, Mr. Chairman. Just continuing on the point Senator Norman just made, what really concerned me about this bill in the beginning, and I spoke with Senator Serval about it and others, if you look at number 4 that Reeves purports to strike out, all other options have been exhausted. And that is an absolutism. And God knows I don't want anybody shot that shouldn't be shot, and I would be the first one to stand up and try to stop it and go after anybody who did. But that's an impossible standard. All other options have been exhausted. There is not a case, and I know the chairman does a lot of work in the Court of Appeals, there will never be a case where an officer used deadly force where a reviewing board or higher authority couldn't look at that and say, well, they could have done this. What I think this bill does is it makes it more reasonable by saying whether options other than deadly force were exhausted, which is, I think, what we want to do. It no longer becomes an absolutism that you could always find where they could have done something differently. But keep in mind, these are split-second decisions, and most time these people are very nervous or afraid or concerned for their lives themselves, and they have to make these decisions in a split second. It is much more reasonable, the language that we have before us, given the circumstances that are going to be operated under. And I hope that we can give this serious consideration. We know that these bills had problems. We knew that we were going to have to fix them, and I would much rather fix them now than having to wait and see the problems that evolve once the bill does go into effect.
Let me say, I don't think this bill changes what we did last year in any significant way. It just redoes it. The last category, you said whether options other than deadly force were exhausted or did not reasonably lend themselves to the circumstances. That replaces paragraph 4, which says all other options have been exhausted or do not reasonably lend themselves in the circumstances. I don't see the significant difference there. So anyway, we operate by motion. And been moved to report to bill.
Mr. Chair.
Yeah, Senator Serval.
Peterson.
Senator Peterson.
Seems to become a theme. I got to raise my hourly billing rate.
Yeah, you look alike. Go ahead.
I just want to say I'm going to make a substitute motion, and despite my respect for Senator Reeves, and this is a good discussion. It's also a discussion we had last summer. I think let's at least let the law take effect, and then we can make changes. But I think to not even let the law take effect is disrespectful for what we went through last summer. So I'm going to move to PBI.
Okay, good point. All right, been moved and seconded to pass the bill by indefinitely. Please vote aye if you agree. If not, vote no.
Ayes 9, no 6.
9-6, the bill is TBI'd. You can take a look next year, Senator Reeves. see where we
Mr.
are.
Chairman, I think I have one more bill, 1361.
All right,
and it has to do with the civilian review boards that we had put into place. I had talked to a lot of our law enforcement about this. We seemingly, in fact, today in Marijuana Sub, talked about putting people on the advisory board or the governing body of the marijuana committee that had some experience with marijuana, whether they've been convicted of it or just all gamuts of prior experience with regard to marijuana and you name it. There's a bunch of stuff in that 200-page bill. So when talking with our law enforcement, they were concerned that on some of these law enforcement civilian oversight boards, that they would get no one that had any experience with law enforcement, no understanding of it, and I think Mr. Huggins articulated that a little bit, and those of you who've gone down to the state police and done a shoot, don't shoot drill will understand, go through it once and understand that it is a split-second decision. So what we tried to do was come up with some elements that we think should be some basic level of understanding and how to get that, to be appointed to that. I'm certainly open to some amendments. I talked to Senator Boysko about some of them, or at least, the bill requires at least 2 members of law enforcement civilian oversight to have specialized knowledge in law enforcement activities or operations. I'm happy to adjust that to 1. At least somebody on one of these boards has done a Citizens Police Academy, gone on a ride-along. If you've never done that, that's pretty important to understand how that process works. So that's what the intent of the bill is.
Senator Reed says, any locality established or indicated they want to establish a civilian review board?
Mr. Chairman, there are those ones that have police as their primary law enforcement. Of course, a lot of our sheriff's departments are run constitutionally by the elected sheriff, and it just depends. But there are some that have police departments.
Mr. Chair.
Who's already set up one? I'm not aware of any.
Mr. Chair, Deeds here.
Senator Deeds?
Charlottesville has one. They've had one for a year or so, and I think
Fairfax,
there's one,
Alexandria.
Northern Virginia.
Really?
This is, again, a bill that changes something we did this past summer, and I just think we have to wait and see how it's going to work before we make changes. I'm going to make a motion to PBI.
Okay, it's been moved and seconded to PBI. Does anybody insist on saying anything about this bill, Senate Bill 1361? I'll give everybody 30 seconds apiece. Anybody want to speak in favor of it? Anybody against it? If you're against it, raise your hands. Okay, I see 3, you have 4 hands, 5 hands. Okay.
Mr. Chairman?
Yeah, Senator Serval.
I'm pretty sure the people that want to speak would support Senator Deeds' motion, so maybe we ought to do his motion and then see how it goes,
Okay,
and then take the testimony if his motion fails.
We've got to move along. Senator Deeds' motion is made and seconded to pass the bill by indefinitely. All in favor, vote aye. All opposed, vote no.
It's 906.
9-6, okay. Thank you, Senator.
Thank you, Mr. Chairman.
Yeah. Okay, the next is Senator Vogel, Senate Bill 1344. Okay, go
Thank
ahead.
you.
Yeah.
Thank you, Senator Edwards. Hold on, let me mute my committee. Apologize.
Okay.
Mr. Chair and members of the committee, I have Senate Bill 1344. And just by way of very brief background, because I know the members of the committee are fairly familiar with this code section and aware of a change that we made previously. As you know, we passed legislation to adopt safe reporting legislation or safe reporting process in Virginia, whereby you're exempt if you report an overdose for yourself or for someone else. And I think that's a worthy goal, and I think super important. Can you hear me? For saving lives. What this bill does, it amends that safe reporting language to change it from a total exemption to a deferred disposition. And then once you fulfill conditions of drug treatment court, then your charges or any further proceedings can be dismissed. The goal here, and I'll let some other folks who I know have waited a very long time speak to this, the goal is to save lives and to get people treatment. Because one of the unintended consequences of taking people completely out of the system is that you are left with only one option, and that is basically voluntary admission if you have an addiction issue or a persistent problem. And as I think many people in law enforcement and in the addiction community will tell you, that's very difficult. The goal is here not to create a disincentive or to roll back in any meaningful way the efforts that we made before to encourage people to report and to make them feel safe about calling and reporting an overdose. But the goal is to come up with some process whereby we have the ability to get them the help that they need. And I've worked with a lot of people in my community where we have a really serious opioid crisis. I've carried legislation in the past and have always been on the same side. I know there are some folks who are in opposition to this because they believe that this is a step backward. But I think if you hear from my local sheriff, who's been a big advocate for this change, who has served on the governor's substance abuse advisory council and has been really active in this area, as well as another person who's come here from Fauquier to speak, they will, I think, be able to speak to what some of the unintended negative consequences are for those people who are in desperate need of treatment and aren't now in a posture where they'll have that option. So with that, Mr. Chair, I will turn it over, if it's okay with you, to my local sheriff, who I know wanted to speak on behalf of the bill. And then at the end, should the committee decide that you want to report the bill, there was a request for a line amendment from the Supreme Court. But maybe we'll take that up at the end.
Well,
Mr. Chairman.
Request? Yeah, Senator Morrissey.
Surville. Thank you, Mr. Chairman. And this might be a question for council, but when I look at this bill, it's got all this language in here about deferred dispositions and first offender treatment and stuff. We just passed a bill in the special session, which goes into effect in about 45 days, which allows a court to defer and dismiss with the agreement of the Commonwealth, which I believe all these do as well, any charge of any kind. And so it seems to me all this language about deferred dispositions is completely surplusage and unnecessary in light of the bill we just passed March 1st. I'd be curious if either Mr. Quagliato or Benjamin agreed with that.
Agreed.
Mr. Quagliato, Charles, you agree?
Mr. Chair, I'm not sure if I would say it's unnecessary. I think the intent of this bill was to say, if you're calling for help, you will be offered a deferred disposition. If it was unnecessary, it would just be a straight repeal of this section, which I don't think would be the intent. I think the intent of the bill is, if you meet the categories, you can be offered you will be automatically placed in a deferred disposition. There's no discretion for the court. So it is kind of a carrot and stick approach. It's not just the option of it. But to Senator Stoffels' point, the court, after last year, and the court does have more broad discretion in these matters.
Mr. Chairman.
Mr. Chairman.
Yeah, Senator Morrissey.
Charles or Steve, let me ask you this question. We all agree that there's a big difference between participation in a drug treatment court docket. Sometimes it takes 2 years to matriculate your way through versus simply first offender treatment. Do you agree with that? Two different things. Drug court, which is often, like I said, could be as long as 2 years, where you're required to maintain sobriety. You have to you might have 2 or 3 drug tests a week. You have to maintain a job. You fall back.
Mr. Chairman, I would agree with Senator Morrissey to that point. I think the bill was designed to take those situations where first offender may not be applicable because of the person's previous criminal history, but to his point that yes, first offender is the easier program than drug treatment court, and by easier, less onerous.
Given that, Mr. Chairman, may I ask the patron a question now?
Go ahead.
Senator Vogel?
Yes, absolutely.
All right, here's my question. Was your goal in authoring this legislation, you wanted to steer more people to drug court, which is, by everybody's estimation, judges, prosecutors, defense attorneys, a wonderful program, but it's a hard program, but it helps them get the addiction out of, helps them beat back that demon of addiction. Was that your goal, to get more folk into drug treatment courts as opposed to first offender deferred disposition?
My goal is to get more people into drug treatment courts. That's accurate. And my goal is to get because right now your only other option is voluntary admission, and we have a whole population of people who are in desperate need, and had they the opportunity, their lives could be saved. Certainly.
Okay, all right.
One final question,
We
Mr.
gotta-
Chair.
We got to move along quickly.
I know, I got to feed the kids too. On line 44, wouldn't you be better to put shall instead of may? On the last word on line 44, it says may. Why not shall be offered? Instead of may be
I'm okay
offered.
with that.
Mr. Chairman,
Yeah,
it's Steve.
Steve Benjamin, go ahead.
In having this discussion, the committee might want to recall, if I recall correctly, that the reason for this bill was motivated by an extremely impassioned and emotional presentation by, I think it was B.J. McGee and his wife, because their daughter, as I recall it, had died because the person who provided the drug was afraid of any criminal exposure.
Yeah, I've had cases.
so,
yeah, that's
and
exactly what the problem was. Yeah.
Yes, and so what this bill does is
Unravel that.
yes, unravel that. So
Okay.
just a reminder that
Okay.
that was the
now
purpose.
let's go ahead and hear the sheriff. Sheriff has something to say.
Mr. Chairman.
Rather than repeating what everybody's saying, I want to hear what the sheriff who's asked for the bill, what his position is. The sheriff of where? Winchester, or where's the sheriff from?
Bob Mosier, who's the sheriff in Fauquier County.
Fauquier, okay, Fauquier. Okay,
He's
go
not
ahead.
on the line.
Sheriff, go ahead. What's your position?
Yes, so, Mr. Chairman, members of the committee, I'll be brief. It's really twofold, what we're looking to do. People that would be arrested would be introduced into the system. And the system being one that would allow, at least here in Fauquier County, something that we built upon, a situation where we would make an arrest and it would be prosecuted, but with the understanding that if they completed guidelines that were presented by the Commonwealth Attorney in the bill, and I'm sure he wants to speak to it as well, is that the record would be expunged. We do not have a compulsory way to get someone to get treatment. And what we had, the testimony that we had with Senator Boysko was from a mother who had 3 children that were in the various parts of the criminal justice system, and one son that had died as a result of a heroin overdose. So we figured out a way to where if we made an arrest and they cooperated and we had a way to get them before the court, then they would be accessible to the Community Services Board and receive drug treatment through Vivitrol. So you would have both behavioral assisted treatment and medically assisted treatment, along with follow-up care after they're discharged from our adult detention.
You have a drug treatment court in Fauquier?
No, that's the thing. We don't have a drug treatment. And I don't want to speak for our Commonwealth Attorney, but that is resource intensive. And we are never going to get to a point, I think, in all across the Commonwealth where we have that ability. But what we've crafted here locally does provide for a level of care instead of just relying on the person to voluntarily present themselves for treatment, because that's just not happening. We have deaths as a result, and we'll continue to have deaths.
How do you encourage people to cooperate unless they get immunity? I think that's
Well,
the
that's
problem.
what the bill does.
Huh?
Can I ask the Commonwealth Attorney to take it from here, sir?
Be good. Yeah, Commonwealth Attorney, go ahead. State your name.
Scott Hook. I'm the Commonwealth Attorney for Fauquier County.
Okay.
The reason I got involved in this bill, let me tell you, the reason I got involved as Commonwealth Attorney is because I buried my best friend from a drug overdose. So I don't come from the same position as many other Commonwealth attorneys. I ran on a campaign and we need to offer help. The problem I saw with the existing bill, and we're seeing this repeatedly, is what our sheriff's office has become is a drug trash service. They show up, they pick up the drugs, the person's overdose, and they simply take them away to be destroyed. We're trying to establish a drug court here in Fauquier County, and Senator Morrissey's right. Absolutely, there's a difference between the first offender program and the drug court treatment program. And we would love to have that here, but it's a matter of funding, it's a matter of space, it's a matter of people. So when crafting this bill, that's why we give the option. If you've been in first offender before, we recognize that rehabilitation doesn't always take the first time. It didn't take for my friend Dan Duggan, who I buried. you can still get into the first offender program if that's all the locality has to offer. And we can craft the first offender program to cover whatever particular need you have, depending on your addiction. Also, getting into that first offender makes you eligible for grants and funds that a lot of people addicted to opiates, which is our major issue right now, at least in Fauquier County, they don't have the funding for treatment. So that gets you in. Now, if you are in a jurisdiction that does have drug court, well, that's even better because that is a holistic approach that includes where you live, where you work, makes opportunities. So that's great. But in a rural county like Fauquier County, where we don't have a drug treatment program, other than what the sheriff has put together through faith-based, through medicinal, through secular, all the things he's done, but you don't get there until you've overdosed and you've been arrested. Now, the bill calls for, if you were to fail in the program, it's just a misdemeanor. It is not the end of your life. It does not saddle you with a felony conviction, which I don't think you need to be saddled with. So this is an attempt to bring more people into the program. If they fail, we know a certain percentage of people are going to fail. It's a soft landing. You have a misdemeanor, a class 1 misdemeanor, which you can also get from a reckless driving ticket or a myriad of other offenses. So what we're attempting to do is when I look at people, somebody who's overdosed, and all we can do is go out there and say, hey, there's a lot of great programs. We're not going to fund them. We're not going to take you to them. They're not going to be available to you unless you find funding somewhere else. All we're going to do is drive your drugs to the trash. And then EMS says, can we offer you this help? No, I don't want it. And we see this repeatedly. The person gets Narcan, gets up, and simply says, thank you for coming. I don't want it anymore. And they walk away. That doesn't help that person who's overdosed. When I look at a person who overdosed, I'm looking at a person who has saw the light at the end of the tunnel. That's the person we can reach out to and bring them into a first offender program or bring them into a drug court program. We don't have that option unless we can bring them into the court system. So that's what we're asking the legislature to do.
Yeah, Senator Sherville.
I have a question for the Commonwealth Attorney.
Go ahead.
Thank you. I mean, it sounds to me like you're upset that you don't have a drug court in your jurisdiction. Is there some reason you guys couldn't solve these problems by having a drug court in your circuit?
Actually, Senator Sherville, you don't go to drug court unless you've been arrested. So we could have a drug court, but we're going to lose all the people who I think are the most receptive. We've just saved their life. That's the issue. We can create drug courts, but if you don't get into the court system, you're not eligible for drug court. So drug court doesn't matter. And yes, I would love a drug court and we're working on it. And so any help you can offer, we appreciate. But if you overdose and you don't get into the system, you don't get into drug court. So drug court doesn't matter to these people. It's not an option.
Mr. Chairman.
Yeah, go ahead.
McDougall.
Who's this? McDougall.
Mr. Chairman, I understand what he's saying, but I think this is a real more basic decision. And the basic decision about life comes more immediately. What we heard over the years and what the case that Mr. Benjamin talked about with Ms. Dillon, when the people that gave her drugs were there, the police knocked on the door, they were afraid of getting arrested, so they left her in the closet and she died. So, Mr. Chairman, he's right. Some people are going to call, they're going to get hit with drugs and survive, and they might use again. But they will survive to have the opportunity. And what we are finding before is that those individuals just don't call. They just do not call. They don't ask for help, and so they end up dying before they get any other opportunity. So it's not perfect. If people are addicted, some of them are going to make the choice to continue to use. But this does give the opportunity to save those individuals' lives, and hopefully that will be enough for them to get into a program, get help, ask the family, ask other communities. But we're making the immediate decision that the priority when you are overdosing is to get medical help, not to get arrested.
Mr. Chairman.
Yeah, Senator Sherville.
Sherville, thanks.
We've got to wrap this up, okay?
Right. I mean, this law, likewise, has been on the books now for 7 months. And the prior version of this law, which, by the way, this law also undoes, has been on the books much longer than that. And so this law takes us back years compared to what it was. I understand there's perhaps a policy disagreement. Some people think the criminal justice system might be the best way to deal with addiction and overdose. But I thought the policy decision we made last year was that it is not, and we wanted to make sure that if somebody calls in because their friend's ODing, that they not get prosecuted. There'd be no fear they get prosecuted, because I've seen people get prosecuted by aggressive prosecutors when they call in and when their friend overdoses, even though they often meet the terms of the statute. It's just, so again, we're here revisiting something we just figured out 6 months ago. I think we took probably, I sat there sitting behind Senator Boysko last year in the House listening to like an hour of testimony from overdose families talking about this. If we revisit every single bill, every session, and we're doing the same stuff again and again and again, we're going to be here hearing the same stuff again and again and again. Okay. I think we need to give this time to percolate and see how it works before we go back and undo everything. So I would move to PBI the bill.
We need a motion. Motion to PBI the bill been seconded. I think it's true that this is a fairly new bill that we passed last year. It really hadn't had time to sink in, and I agree with Senator McDougall. When somebody's in deep trouble, they need a doctor rather than the fear of being prosecuted. I understand where you're coming from. Hope you all can get a drug treatment court. I really do. But I'm going to call the motion been made and seconded to pass the bill by indefinitely. Doesn't mean you can't bring it up next year and continue looking at this very complicated issue. But the motion been made to pass the bill by indefinitely. Please vote yes or no.
Thank you, Mr. Chair and members of the committee. And I also want to especially thank Scott Hook, our Commonwealth Attorney, and Sheriff Mosier for waiting and for their work on this.
I want to thank you, all of you all agree. I agree with you 100%. Thank you for bringing the bill, Senator Vogel.
Vote is ayes 11, noes 4.
Yeah. 11-4. The bill has been passed by indefinitely. Okay.
Mr. Chairman, quick question.
Yeah.
Clerk told me that we have 11 more bills. Should I wife is tied up, should I send a message home for the 3, 4, and 5, and 8-year-old to fend for themselves tonight? Okay.
Let me do, how much more do we have? Stanley's bills are putting off till Monday, is that right? Yeah, two Stanley's bills to Monday. And then there's let me do, I got two simple bills I present myself. I put them off from last week. One from the Supreme Court and the others from the DMV. They're very simple bills. The first bill is the driver's license suspension bill, Senate Bill 1213, and this is requested by DMV. What this does, it authorizes the Department of Motor Vehicles to issue restricted driver's...
Mr. Chair, do you want me to take over?
Yeah.
Senator Edwards has a bill, and I'm going to entertain a motion to PBI's bills. Senator Edwards.
Okay, my bill, Senate Bill 1213, DMV asked for it because it would authorize DMV to issue a restricted driver's license to individuals with driver's license suspensions resulting from drug-related offenses. Last year we provided to repeal suspensions of driver's license because of drug conviction. And there are people, however, that before last year already had their licenses suspended. So this would allow DMV to go back and it grants the court the authority to issue restricted driver's license to individuals whose driver's licenses were suspended prior to the repeal of the law.
Mr. Chair, and I'm working my way down the bill. I'm wondering if there's a sunset clause or there's a need for a sunset, because at some point there won't be any more people with licenses suspended for drug offenses, will there?
Well, people who already had their licenses suspended before we changed the law last year. It helps these people. It permits DMV to issue restricted driver's license to individuals whose driver's license suspensions resulted from drug-related offenses. There's no fiscal impact. It just gives authority to DMV to go back and help people whose licenses were previously suspended before we changed the law.
Are there any questions for
One question, Mr. Chair.
Mr. Chairman,
Morrissey.
Thank you. Senator Edwards, does the defendant need to take a proactive step and make application to the court that had suspended his license, or will DMV do it on their own volition?
I think they have to go to court. Let me see here. That's a good question.
I'm wondering, because you told us DMV brought this to you.
Yeah, DMV asked me to put the bill in.
Mr. Chairman, Charles here. They would have to go back to court simply for the fact that the DMV is not going to know if there's another reason why the person's license is suspended. This just deals with those people who lost their ability to get a restricted license because they were caught up in the repeal from last year for non-drug offenses. So if the person license was suspended for a different reason, the court would be the check to make sure that they are getting their license back appropriately.
And
Would you entertain a motion, Mr. Chair?
I would, yes.
All right. This bill captures those people that can't avail themselves of the new law. I think it's very purposeful and practical, and for that reason, I'd make a motion to report.
Mr. Chairman.
Senator Norman, I think, has something.
Mr. Chairman.
Senator Stanley or Senator?
Yes. Mr. Chairman, addressing the patron, I was the patron of SB 1, which ended license suspensions for non-payment of fines. That law is just now being used. We're just starting to get used to it. Why do we have to change it all of a sudden under the same guise of what we've been thinking of today in these other bills? I think we maybe should just let this coagulate a little bit and then maybe come back to it. I want to be philosophically exactly the same in how we're treating other laws.
You're out of order, Senator Stanley.
Senator Stanley,
Senator Morrissey had a motion. If we could hear, if there are questions for the patron,
when
serious
Hanson,
questions.
it doesn't undo your bill at all. It adds to it. You've helped people going forward. Now help the people going backwards.
I'm not sure it was a serious question, Mr. Chairman.
Mr. Chairman, I can assure you it was not a serious question.
Are there those in the public that would like to speak to this bill?
That's why I love Bill Stanley.
Well, then we need a second for the motion.
Second.
Are there further motions, or is there any more discussion? If not, please open the roll.
Mr. Chair, we do have public comment.
I thought we'd ask for that. Okay.
Objection.
If there are people in the public that need to be heard, the bill is in good shape.
Don't grab defeat from the jaws of victory.
If there are people that are opposed to the bill, that would probably they would probably be the ones who would want to be heard the most, I would think.
I know of no opposition.
Are there those from the public that need to be heard? Going once, going twice. Please open the roll.
Can you vote for me?
Ayes 14, no 0. You got your bill, so, Mr. Chair.
One other bill. It's
One
very
other
simple.
bill.
This is just a simple Senate Bill 1242, personal appearance by two-way electronic video and audio communication in certain situations. The Judicial Council is recommending it. What it provides is, with consent of the court and the parties, all appearances in a court may be made by two-way electronic video and audio communication for the purpose of: 1, entry of a plea of guilty or nolo contender and the related sentencing thereof, charged with a misdemeanor or felony, again with the consent of the court and the parties; and 2, the entry of a nolo prosequi that is dismissing a case, or 3, the adjudication of the alleged violation of probation. The bill is a recommendation of the Judicial Council.
And this could only occur if all the parties agree.
Everybody's got to agree. If you don't agree, you don't do it.
Are there questions of the patron?
No.
Are there those in the public that need to be heard? No. There are. That oppose. Are there those in the public that oppose the bill? I would think those would be the comments that need to be heard. Got a motion and a second. Are there further motions or any more discussion? If not, please open the roll. Your bill is reported, Mr. Chair. I give the chair back to you.
Mark Dix, did you want to say something? I just noticed you're there.
Yes, Mr. Chair. Mark Dix on behalf of the Virginia Trial Lawyers Association. We
we don't oppose the bill, but there were concerns raised by our criminal law practitioners, which I just would like to point out, and that is with respect to including the sentencing and the probation violation. Our criminal law practitioners feel that those are two seminal events at which there should be a requirement for in-person communication. With the probation.
Mr. Chair,
consent of the parties.
Mark, you understand that the lawyers have to agree.
Mr. Chair, absolutely. But the criminal law practitioners, as we all know, sometimes when you're before a judge and they say, are you really not going to consent to the electronic communication? It's very hard for a lawyer staring down a judge when their preferences are known. And so absolutely, we understand it does have to be with the consent, but they're worried that there may be pressure from some quarter to agree to these. And with sentencing and probation violation, again, we feel that those are two events where we should still have the importance of in-person appearances. Thank you.
Thank you. I just did one the other day, as a matter of fact, sentencing hearing in federal court. It's a long story. My guy didn't even speak English. That was done remotely. And everybody agreed. Yeah. Huh? I'm sorry, Senator Stewart. Okay, yeah, Senator Stewart, got a simple bill. 1336. Yeah, can you push your microphone? Yeah.
It allows a court, when they give someone a restricted license outside of the DUI realm, which we have already done last year, Senator Searle did that, to make the only condition of that restricted license that they have a breathalyzer on the car, that they can't operate it without that breathalyzer. We did that for DUI. People are taking advantage of that, and this just broadens that scope a little bit. If there are any questions, Senator Searle will be happy to answer them, because this is one of his children that needed a guardian.
Okay. Senate Bill 1336. Are any questions of the patron, which is not Senator Searle, is Senator Stewart? Okay. Anybody have any questions at all?
Mr. Chairman,
Yeah.
Finance has requested this bill.
Okay, this got to go to Finance. All right. So the motion would be to report and re-refer to Finance, Senate Bill 1336.
So moved, seconded by Boy Scout.
Is there a second? Senator Obenchain seconds the bill. Seconds the motion. All in favor of the motion to report and re-refer to Finance, Senate Bill 1336, vote aye.
Ayes 15-0.
Okay, what's left?
I've got 3 bills, but they're all private bills that are going to take a little bit of time.
Well,
Mr. Chairman.
yeah, Senator Searle.
Morrissey has a bill that we passed last year. It wasn't uncontested, but we passed it last year. If we just conformed it to last year's bill and send it out of here, unless everybody wants to talk about the whole thing again, we could do that. But
Morrissey, where's your bill? 1306, assault and battery. You say we did it last year or didn't do it last year?
it was my bill last year
What did we do?
in the special session.
What did we do? Kill it?
No, we passed it. The House killed it.
Oh, I see.
Mr. Chairman, I'm trying to get this bill passed. Senator Searle, I want to get passed.
So it passed the Senate last year, is that right? Well, how did it pass last year? Was it unanimous or what?
Mr. Chair.
No, it was not unanimous. It's very controversial.
Oh, great. How many hours do you want to take? Okay, Senator Morrissey, your children need to eat.
Thank you, Mr. Chair. Shall I proceed?
Yes, go ahead.
All right. This bill, we've heard a similar version before, where a defendant assaulted a police officer, and we discussed whether it should be a felony, whether it should be a mandatory 6 months, et cetera. Let me just tell you the nuances with this bill, and there have been many stakeholders that have been involved, and we've come to a meeting of the minds. First of all, if you look at line 21, if any person commits an assault and battery resulting in a bodily injury, and the person is a police officer, it's still a Class 6 felony, Senator Normand, and the person still has a mandatory 6 months in jail, Senator Obenshain. I want to repeat that. If it's an assault and battery resulting in any bodily injury, still mandatory 6 months, still Class 6 felony. That, I hope, would assuage folks on that side that had some concerns last year, and I'm saying that respectfully. Now, there is an important provision beginning in line 38. If a person is charged with this offense and the person has some physical or mental capacities that would diminish his, to the extent that he needs counseling or supervisory assistance, or he has been diagnosed under the autism spectrum, notwithstanding the assault on the police officer, either the judge or jury may find that the accused is not guilty of violating this subsection that I just referred to, but rather guilty of simple assault or assault and battery, and it may be punishable as a Class 1 misdemeanor. So if there are some intellectual deficits, some physical deficits, he's on the autism spectrum, then that person who has assaulted the police officer could still be found guilty of a misdemeanor. Then I'd direct the committee's attention to the end of the bill, beginning on lines 100.
Mr. Chairman, could I interrupt Senator Morrissey there before he moves on?
Yeah, Senator Stewart.
With your line 40. Senator Morrissey, I asked this question, a genuine concern. So a couple of years ago, we passed a bill that I had been carrying for a great many years, which allowed...
Mr. Chairman, I know where this is going, and I can answer it.
Well, just let him answer the question first.
That came up on the House side, and Senator Morrissey's bill, it addresses your concern in lines 47 and 48. You're talking about your bill to allow a deferred disposition for the autism spectrum. So we included a reference in there to make clear we weren't overriding that bill you passed.
Go ahead, Senator Stewart. Ask your question.
One of the, Mr. Chair, if I may.
Yes.
Okay.
One of the things that we discussed last year was that situation where a defendant assaulted, and as everybody knows in this room, an assault is measurably different than an assault and battery, such as the defendant reaches back with his arm as if to instill fear in the police officer, but doesn't do it. That defendant is guilty of assault, not assault and battery. But under existing law, could be charged with a felony with a mandatory 6 months in jail. Think of the situation where the defendant reaches back and then has a moment of clarity and decides not to do that.
Mr. Chairman?
Well, let's let him finish up. Go ahead.
Can I just ask,
yes,
and I apologize, but to that point, would that also apply if he had a baseball bat and swung it at the head of the police officer and just missed?
I don't think so. That'd
be an assault, but not a battery.
A simple assault?
You got to have a
So
battery.
with murder in his heart, intending to bash the brains out of that police officer and just missed, you can't charge him with a felony.
Well, you could. Attempted malicious wounding.
Mr. Chairman?
Yes, Senator Servo.
Thank you. We had this discussion last year, and this is the part of the bill that does not conform to the version that passed the Senate. And one of the concerns that I had about the bill was there was an officer in Fairfax who I sat down and had a beer with when this was introduced, and he told me a story about how he was once called to a house and for a hostage situation, and as soon as he got out of his car, the person unloaded his firearm at the officer. And the officer called in backup, they encircled the house, they eventually detained this person, and it turned out that the person was shooting blanks, and he was trying to commit suicide by cop. And they tried anything they could to figure out what kind of felony they could charge him with. The only felony they could charge him with was felony assault on a police officer, not assault and battery, but assault because brandishing is a misdemeanor. And so that was the only felony they could charge him with. And I thought that anecdote to me said so much that was why I got rid of the bodily injury language. The bodily injury issue has a lot of ambiguity with it as well, but but that was why I left the assault in there. And I think the simplest thing for us to do to minimize discussion, whatever, would be to conform that piece, at least 40 lines 23 and 24, just delete that addition and those strikes, leave the rest of the bill as is, which is how it pretty much left the Senate, with a couple tweaks. They picked up the Stewart, what I'll call the Stewart Amendment, and we clarified the mental illness stuff. We made an explicit reference to autism and something else, and I think that bill sort of puts in a posture where everybody, unless they want to change their position, should feel comfortable voting the same way. So, Mr. Chairman, what I would do is I would move to get rid of the edits on line 23.
Mr. Chairman, methinks my participation in this is unnecessary.
Well, the problem I'm having with the bill is on line.
You're another guardian.
Senator Morrissey, on line 40, it says, if any person is charged with committing an offense in violation of this subsection where the degree of culpability is slight due to the person's diminished physical or mental capacity or diagnosis of autism spectrum disorder as defined in such and such, or if there's no bodily injury, or a jury or the court may find the accused not guilty of violating this subsection, but guilty of simple assault and battery in violation of Section A, blah, blah. That is a confusing sentence, and I don't understand it. I don't know how a jury would understand it. What is the degree of culpability? Is slight? Do the person diminish physical or mental capacity? I mean, these are things you take care, you look at sentencing as a person's mental capacity.
Mr. Chairman, I'm sorry, what line are you referring to right now?
40, 41, and 42.
Okay.
It's a confusing sentence. I don't know what its culpability is. Slight due to
Mr. Chairman.
diminished physical or mental capacity.
Mr. Chairman.
Yeah, go ahead.
The bill is actually unnecessary.
Thank you. Mr. Chairman, the language about the culpability being slight is taken straight from the improper driving statute. That's a standard that's been in the code for probably 30 or 40 years now.
Proper driving is a very different situation, though, than assault and battery. I know in proper driving you're charged with something about driving, but the judge on his own can reduce it to improper driving. You can't charge a person with improper driving. A judge can do that.
Mr. Chairman, this is Charles. I have a possible amendment to that that I could post to LIS, and I could also read to the body that cleans up that language a little bit. And I'll read it first. And it's, if any person is charged with committing an offense in violation of this subsection dealing with the assault and battery against a law enforcement officer, whose physical or mental capacity is diminished to the extent that he needs counseling or supervisory assistance or assistance with activities of daily living or instrumental activities of daily living, or has been diagnosed with autism spectrum disorder as defined in 38.2, 3418.14, a developmental disability as defined in 37.2-100, or an intellectual disability as defined in 37.2-100. A jury or the court may find the accused not guilty of violating this subsection, but guilty of simple assault or battery in violation of subsection A, punishable as a Class 1 misdemeanor. And I published that to LIS now, but I think that clears up some of your concerns in terms of what the culpability slight is. And
Mr. Chairman, I move that amendment. Senator Boysko seconds it, whose proxy I have, along with the prior motion I made, which we haven't voted on.
The problem with that, Charles, is this is sentencing issues. This is not finding of guilty issues. That's the problem I have. It should be left to the sentencing issues, not that. I want to take this whole thing back to Monday. Is it okay?
That's your pleasure.
Without objection, go back to Monday and do some surgery on it.
And I was just thinking, Mr. Chairman, maybe Senator Serville can come into this room by himself with his proxies and debate himself and pass bills or not.
That'd be a good idea. Save us a lot of time and energy.
That's funny.
Okay, is there anything else? What do we have not done that we need to do? Oh, open change. You sure you want to go ahead with your bill? Huh? Which bill is this? Number what? 1123. Senator Obenchain, 1123.
What the hell?
1120. 1124, is that it? Okay. Senator Obenchain, 1124.
Yeah, can't get on the internet. He damn sure took my connection.
Mr. Chairman, members of the committee, this is another bill dealing with financial exploitation of seniors. The idea, this deals with wills, and Virginia is in the minority of states that allows somebody to sign a will as a witness even if they are the sole beneficiary of the will. Most states have turned away from that. This prevents the situation, is another effort to prevent the situation that described the other day in which a caregiver prints a will off of the internet, puts it in front of the senior, and she and her son sign as the two witnesses to the will, and then the person elder dies, and those two witnesses execute signed depositions in which they prove the will. They are clearly interested parties, and in most states, they are limited in their ability to sign a will. I have spoken with the Trusts and Estates section of the Virginia Bar Association about this, and they raised a concern that I think is a fair concern, saying that perhaps there are going to be innocent situations in which a family member may sign as a witness. They are not exerting undue influence, and so I think that because of those concerns, and I'd asked Kristen to put together a substitute with some additional language taken from Indiana that basically says that that person's gift is voided, but not the entire will. I still believe that this is an important issue. However, I don't think that on the fly we can address some of the fair concerns that may have been raised. So I would ask that this bill go by for the year. It is an issue, or be passed by indefinitely, with the understanding that I'm coming back. I hope you will remember this issue and that we are continuing to try and work on it. So I hope that the Wills, Trusts, and Estates section will appreciate that as well, and maybe work with me on the other issue that we talked about on Monday.
I think it's a great idea. Without objection, the bill will go by for the year. Jeff Palmore, you agree? Jeff?
Sounds good to me. Thank you.
Yeah, I don't like the bill at all, because the idea of a witness is the capacity of the person signing it, rather than whether they may or may not have some kind of interest in the will. I think we're
Mr. Chair, I think Senator Obenshain's bill raises some important issues with respect to the execution of a will, but I'm a little concerned about the language describing who a disinterested witness would be. I think that needs some work. So I would make the motion to PBI, which has the same effect as passing by for the year.
Yeah, without objection, the bill will be passed by.
I
for
second
the next
that
year.
motion.
All right, all in favor of passing the bill by indefinitely? Is that the motion? Vote aye. All opposed, vote no. Pass the bill by indefinitely. Stanley votes no. He likes the bill. Norman likes the bill too. Anyway.
All right. Ayes 13, noes 2.
Okay. Creed, do you have some bills you want to?
I've got 3 bills that a little bit ago I said that they were going to take some time, and you said just put them off till next week. So I told my witnesses I ran my witnesses off.
I see. All right, we get to, anything else we need to besides Creed's bills? Any other bills? Nothing easy to do, right? We got it all done except Creed's bills, right?
Yeah, yes, and Senator Barker never showed up in the Zoom, so.
Yeah, I think Barker wasn't quite ready for his bill. Huh? All right, we'll put Senator Barker's bill, 1206, confidentiality. I thought he wasn't quite ready for that bill anyway.
Mr. Chairman, I got an email from Senator Barker's office indicating they wanted to be passed by for the day. I thought that was communicated to you. Apparently DJJ raised some concerns about it that Senator Barker's trying to work out.
Yeah, that's good. Okay, and Senator Stanley, these two bills of Stanley's are going by malpractice, cap, and scientific evidence. And, okay, so we're done for the day, right? Yes, sir. We've done as much damage as we can do in one day, is that right?